The Metropolitan Board of Zoning Appeals is now in session for the specially set meeting of December 13th, 2018. My name is Emily Lamb, and I will be presenting the cases to the board for their review in today's public hearing. At this meeting, please silence your phones and devices so the board meeting will not be interrupted. For today's public hearings, the board reviews the correspondence submitted in support of and opposition to these cases. The board also reviews correspondence and recommendations from other government agencies in preparation for the hearings. In today's hearings, staff will present the maps, photographs, and other documents that comprise the case record. At the conclusion of the staff presentation, the appellant will present his or her case to the board. After the appellant's presentation, the board will hear those wishing to speak in support of the appeal. If the appeal has opposition, the board will then hear from those opposing parties. After the opposition presents its testimony, the appellant will have a period for rebuttal. Under the BZA rules, the appellant has 5 minutes for presentation if there is no opposition. In contested cases, the BZA rules allow for 10 minutes for each side to present their testimony. Should the appellant wish to provide rebuttal testimony, the appellant should reserve some portion of the allotted 10 minutes. At the conclusion of each hearing, the board will deliberate and then vote on the case. The board is vested with the power to act on these cases under the provisions of the Metro Zoning Code, Section 1740-180. All section numbers that we refer to come from the Metropolitan Zoning Code, which applies to the entire jurisdiction of the metropolitan government. The Zoning Code was adopted by the Metro Council and became effective on January 1st, 1998. I will introduce the entire Zoning Code and make it a part of today's record. The Metro Code requires a record of these proceedings. Because the BZA meetings are recorded for Metro Nashville Network, it is imperative that anyone addressing the board come forward to the table at the front of the room and speak into the microphone. All speakers should identify themselves by name and address and then make their desired presentation. The Metro Code requires 4 members of our 7-member board to establish a quorum. The code also requires at least 4 affirmative votes to grant an appeal. In the event that 5 or more members are present and the appeal fails to receive 4 affirmative votes, the case will remain on the board's agenda for the next 30 days. Applications that fail to receive 4 affirmative votes within 30 days of the public hearing shall be deemed denied by operation of law. Pursuant to board rules, an aggrieved party may appeal board decisions to the Chancery Court within 60 days of the hearing date. Additionally, an aggrieved party may file a motion for rehearing within 60 days of the original hearing date, pursuant to the terms of the BZA rules and regulations. After that time elapses, the board's decision becomes final and no further action can be taken. If your appeal is granted, you are required to obtain the permit for which you applied. It should also be noted that if false or misleading testimony is presented to the board, any board approval could be revoked at a later date by means of a show cause hearing before the BZA. Mr. Chairman, I submit that all cases have been filed in proper order, all appellants have been notified by certified mail, and all legal notice requirements have been fulfilled. Are there any preliminary announcements for the board today?
None. You are joined by 1 council member.
And we are joined today by 1 council member, Councilman Swope. Would you like to present now or wait until the case is heard?
I'm just here to listen.
Okay. Absent any announcements, no other council members present, I believe we're ready to proceed with the first case. The first case for consideration by the board is item number 2018-606. Ann Ballard is the appellant and owner of the property located at 2619 Essex Place. Is Ms. Ballard here? The property at issue is shown here on the aerial map. Mr. Osborne has the presentation of this case for staff. Is there anyone here in opposition to case 2018-606?
I'm here for Ann Ballard, representing Renee Max.
Renee Max is here and representing Ms. Ballard. Okay. Before we get started with this case, is there anyone here in opposition to any case? That will save us a little bit of time asking that. Okay, so everyone here will have 5 minutes for their presentation. Ms. Max, Mr. Osborne will present the case first, and board members.
This is a specially called meeting of
Yes.
the Board of Zoning Appeals. This is an all short-term rental appeal meeting. We have these on the end of our agenda. We have, because of the length of our recent BZA meetings, we haven't gotten to all of them, so we wanted to call a special meeting so we could deal with the short-term property matter. So all the cases that you hear today, so those watching on the Metro Nashville Network expecting some variance cases or some sidewalk cases, that's just not today. It's short-term rental all the time. So wanted to explain that, and we normally meet, as our rules require, every first and third Thursday of the month. So this is a special meeting where we will meet 3 times in December. So thank you.
And before we hear from Ms. Max, Mr. Osborne will present the case for staff.
So we found out about this case through host compliance. We sent a short-term rental notice on February 9, 2018. It operated from about August of 2017 to February 2018 with about 99 rentals. We did receive a complaint in November. I believe there's a letter in your packet about that complaint as well. It looks like the advertisement was removed around March 2nd, 2018.
So the complaint, was there evidence in the complaint that the property had been rented since?
That's what the complainant was saying in his letter. He had contacted me, had asked how to contact y'all and make his voice heard. So he sent a letter to me, which I passed on. So
Okay.
that y'all could have.
But you don't have any evidence of like a listing being up or reviews past March or anything like that, or?
I do not.
Okay, so if it was done some other way?
Correct.
Okay.
Were there any other complaints or violations during that period?
I believe it's just that one.
Okay. Any questions for Mr. Osborne? Okay, thank you for being here. Please state your name, your
Renee
address.
Max. My address is 718 Starlet Road, Nashville, Tennessee, 37205. Good afternoon. Thanks for holding this extra meeting. I represent Ann. I met her over the summer. I'm doing property maintenance for her. And she wanted to start doing short-term rentals and had me go get the permit, and she told me she did get in trouble last February. She was going to appeal it, but then decided not to, but now she wants to start them up again. So,
When she said in trouble, what does that mean?
oh, she got a letter. So she halted her rentals right away back in February. I didn't know her then.
Okay.
And she gave me the letter where the Airbnb account was canceled, and she canceled it right away.
Okay.
She didn't know. A lot of her neighbors were doing this sort of
So
thing.
does this person,
lives in that house right now?
It's Ann and her family, her son.
so she rented it, according to Mr. Osborne, 99 times, so what she didn't know before that, so what was happening?
That was the first letter. I guess some friends were doing it somewhere else,
Okay.
and she had no,
And so you're helping her through this process now?
yes.
Okay.
Now, are you
She's
managing the
traveling.
property?
I'm doing maintenance there, like
Okay.
cleanings.
Okay. And then is her family, do they have a lot of large parties with people that stay all weekend?
Yeah, she has kids that, she has 7 kids. And some of them are grown.
So it wouldn't be unusual for there to be a large and loud enough party of her family members that would cause the police to be called at 2 a.m.? According
No.
to the neighbor that lives right behind them? So you said you're disputing that happened?
Yeah, I had no,
Okay.
I have no idea about it.
Okay, well, there's a letter from David Honeycutt, who lives directly adjacent to the property, who says that they've had, and so they've only been there 3 months, so they've had lots of incidences, had to call the police at 2 a.m. on November 4th. A woman staying in the house walked through our gate and onto the front porch. It seems like there's kind of a lot of folks there that,
I know that she did a Halloween gathering, so I'm not sure if it was that weekend or the weekend after. It was around Halloween.
well, November, yeah, she may have had a Halloween party November 4th, but she might be the only one in town to do that.
Okay, all right.
Since it would be after Halloween. All right. So and why isn't Ms. Ballard here today?
Oh, she's traveling. She's in Boston. And I have an affidavit saying I'm representing her as well on her behalf.
So this police call was unrelated to her short-term rental activity, it was just a family party?
Yes.
Okay. Now, where, do you live close to her?
No, I live in Westmead.
Okay. And so, How did she not know that we had laws related to short-term rentals and she rented it almost 100 times?
I have no idea how she's not a very, she's taking care of deaf children right now, adopted deaf children, so she's very busy in that.
In her
And
house
she,
she is?
yeah, and she has extra space. She puts them in different schools. They're away at different schools,
So
some
it's
of them.
foster care almost.
Almost foster care, but they're adopted. They're
Oh, they are
actually
adopted,
legally.
okay, so
Yes,
then that's different.
yes.
So where do people stay when they come to this house that rent it for short, is it some certain rooms or where do they
She
stay?
has upstairs in-law suite set up with a private entrance, and she also has a downstairs, which is on the main floor, but it's like a basement set up for guests.
Other questions, board members? Do you have anything else to add?
Nothing else except she pulled this down right away. I have documentation that she did take it down when she did get the
Did
letter.
she cancel future bookings?
Yes, all future bookings were canceled.
How
I
many
did
were
not take
canceled, do you know?
a bunch because she says I was charged 50 and then 100 and then 150. She said it took her a couple of weeks to cancel because she had to do them manually.
Okay, so
Airbnb didn't
word to
assist
the
her.
wise, just sitting here for many, many years. And we really look favorably on people canceling once they receive a letter from Mr. Osborne. But if you work through Airbnb and let them cancel it, apparently most of the time they don't charge you that money. So you call Airbnb.
Well, she probably didn't know that.
Right, but she did
Yeah,
cancel. Okay.
I mean, if I knew her then, I would tell her that.
Right.
You know, I knew
So those
that.
of you looking at home that are in the similar situation, don't rent without a permit, and if you do have future bookings, Mr. Osborne will catch you.
Right.
He may not catch you this month, but he will catch you. Host compliance, they're on this. So,
So did the owners move to Maryland?
She has a house there as well because that's where a special school is.
Okay, who's
Yeah.
special school?
Oh, for two of the children.
Okay,
It's a
And-
special deaf school, because she had him in Hillman, that's why she bought the house. And then her son is back because he had a recurrence of cancer, and he has to go to that treatment center near Vandy.
Is Maryland her primary residence now, or is?
No, it's here.
It's
She
here.
holds all her insurance and all her license here.
okay. Any other questions?
Did she have some written information, what you're referring to? Is that something you want to make part of the record? Is that information she provided to you?
Yes, absolutely. This is an email. Yeah, she said I was frantically trying to cancel
Or should you
them.
want to give that to us, I guess, is that what she's saying?
Oh, yeah, absolutely.
Okay,
Yeah,
Jessica will take it.
you can have that. What else do I have? Yeah.
Okay, if there's no other questions or comments, we are going to close the public hearing, and it's discussion time.
I appreciate the representative of the applicant being here and making the case, but I personally would prefer to hear from the owner herself, because I think that I'm still a little confused on exactly what's happening and exactly, I mean, unless, we want to just, if you permit the applicant to rent early spring, then that's, a year since the last rental, and that's not the last known rental, then that's okay. But I think if it's going to be sooner than that, I'd prefer to hear from the applicant. I mean, the neighbor has testified that that the neighbor doesn't believe that they live there. The neighbors testified that they're loud parties. The loud parties don't, to me, coincide with the family that was described, and so, to me, there's more questions that are left unanswered, and I would prefer to hear from the applicant to really warrant a, go get your permit tomorrow kind of penalty. Just my thoughts.
Let me ask Ms. Max, when is the applicant going to come back to Nashville?
She should be here probably after Christmas.
Okay, so our first January meeting is when, John Michael? The 3rd? January 3rd. Do you think she could be here on January 3rd at 1 o'clock over in the sunny west?
What day of the week is that?
Thursday.
Okay. Possibly. I mean, I'll have to ask her.
And if-
She's been waiting since September for this. You know, I went through 2.5 meetings. Yeah.
But I guess what we're saying and what Mr. Taylor has said that he really wants to hear directly from her because he has questions about, how the space is. And as he also said, he's comfortable with giving the permit back in early spring, which would have been about a year after
The last rental.
the last rental, which is, I think, under statute, you would be eligible
February.
anyway. I mean, so, when you said early spring, what did you mean, Mr. Taylor?
Well, I mean, I just, yeah, in early spring, February, March. I mean, if you're gonna get it, sooner than that, I mean, I think if Ms. Ballard were here and we believe, and she repeated the testimony and could fill in the blanks that, we had, and then I think it might be something that we would say, fine, go get your permit. It's been 9 months since you truly last rented, and you've satisfied to our satisfaction the complaint of the neighbor.
Okay.
But I don't think that,
So.
I don't think that we've heard an adequate explanation for the complaint of the neighbor to warrant something different to me. That's
Okay,
just-
so our options are your friend and client coming back in either the first meeting in January or the third meeting in January, or in her absence, as Mr. Taylor said, that, sometime in February or March, we could vote today that she would be eligible to rent again.
What do you think? I have my husband here just for support. Yes. Ask her if she can come on the 3rd?
Okay.
Okay.
So the representative wishes that, so we will, John Michael, let's tentatively put this back on the agenda for the first meeting in January, which was January 3rd. And if the applicant cannot attend that meeting, please contact the codes office and we'll schedule it for another
Okay.
meeting.
Jessica?
Yes.
Email Jessica?
Yes, okay?
All right.
So I'll just formally move we defer that to the 3rd if we
Okay,
need.
motion to defer, is there a second? Motion's been made and properly seconded. All those in favor signify by saying aye. Aye. Opposed, passes. Good luck.
And that's a regular meeting?
Yes, 1 o'clock,
Okay, so
and in
she'll
the,
have to be-
and in the Sunny West building, blue room that you've been in.
Thank you.
Okay, thank you.
Good luck.
John Mike, Emily. Yes. Oh.
The next case for consideration by the board is item number 2018-618.
And first of all, I'm sorry to interrupt, and we have a familiar face and a new employee and representative of this board. Emily Lamb is a lawyer and has helped us out as our lawyer, but many people know that our old zoning administrator, Bill Herbert, is now the head of the codes department. And we teased him that, the Metro has had 2 zoning administrators, Sonny West, the aforementioned person who the room is named after, and then Bill Herbert. We thought he would last decades like Sonny, but he's moved upstairs to run the planning department. And then John Michael is now our new zoning administrator, therefore his job was open, and Emily has moved over to that job. So welcome to the BZA in a new role, and thank you for wishing to continue your service to metropolitan government, and congratulations again, Emily.
Thank you, Mr. Chairman. I'm happy to be here.
Yes, so continue.
The next case for the board's consideration is item number 2018-618. Dong Hong Zhu is the appellant on behalf of Zua Ding, who is the owner of the property located at 2818 Belcourt Avenue, shown here on the aerial map. The appellant is challenging the cancellation of a short-term rental permit that was issued to Mr. Zhu due to a change in ownership of the property. And often in cases like this where permits are canceled due to a change in ownership, codes receives an argument from the permit holder that relies on section 1716-250E4K, I believe. And that section of the short-term rental ordinance states that a short-term rental permit shall not be transferred or assigned to another individual, and that the permit may not authorize any person other than the person named on the permit to operate the property. So oftentimes we receive the argument that the permit can't be transferred, but that an ownership itself does not affect that permit. While it is true that that section of the code states that a permit can't be transferred, we at Codes also read that provision of the law in conjunction with another provision of the short-term rental ordinance, Section 1716-250E1 and 1716-250U. Both of those provisions of the ordinance state that no person or entity shall advertise or operate a short-term rental property without the owner of the property first having obtained an STRP permit. So Code's interpretation and our consistent application of that interpretation of the law is that when property ownership is transferred, the new property owner must come in and obtain a permit. That's what happened in this case. We, as is our practice and a consistent application, applied that same interpretation on this, canceled the permit, and I believe that is what led to the appeal today. Mr. Holland is here on behalf of the appellant and property owner. He will present their arguments for the board. Mr. Holland, there being no opposition present, you will have 5 minutes to present your board for the case, and let me get to your.
Yeah, thank you.
They also have a
Oops, I just did that.
council member, Berkeley Island in the file.
Okay,
No, that's your
that's
fault.
mine. And also, while I'm looking for this, I believe
Thank you.
Councilmember Berkeley Allen sent a letter in opposition to this stating her position with respect to what the law stated. So I'll draw that to the attention of the board if y'all want to look at that. I'm trying to get this. Oh, wait, no, that's not what I'm trying to do. I can't see slideshow from beginning. Here we go. Mr.
Awesome.
Holland.
Thank you. Thank you, Mr. Chairman, members of the board. My name is Jamie Holland, live at 511 Rosebank, and represent, for sake of simplicity, she goes by Grace Shue. So if you want to call her by her first name, Grace is a lot easier, especially for me, to pronounce. Ms. Lamb indicated at the front, she mentioned two ordinances in Title 17. I think it was 1716-250E1 and 1716-250U. If I misquoted her, I apologize, but none of those ordinances apply to this permit. So if we could go to the first slide.
Okay, wait a minute, Counselor, you just can't make a passing.
I'm right here. The permit at issue in this appeal was issued April 17, 2015, property zone RS 7.5. The permit is a non-owner occupied permit. Next, please. So what ordinance applies? Not my passing comment. Pursuant to the Short-Term Rental Unit Act, Tennessee Code Annotated 137601 et sec, the applicable ordinance is the ordinance at the time the permit was issued. So
You're saying when the Metro Council or other legislative bodies pass laws that they don't apply because someone got a permit years ago? Is that what you're telling us?
I'm
Mr.
saying
Holland?
the Short-Term Rental Unit Act
No, I
specifically says the ordinance at date it was issued applies. These subsequent ordinances do not apply.
we have a Metro Council member sitting behind you. So
I
you're saying
understand.
that any laws that he passed outside of when your client got a permit just don't apply to your client?
The next ones that were applied were BL 2016-492. The next one was BL 2017-608. And due to the state statute, neither one of those ordinances apply to this permit.
So how does this conflict with the state statute talking about no person or entity can get a short-term rental permit without the owner getting the permit? How does that conflict with a state statute, which I think is 251, 716-251, and then 251U? How does that doesn't conflict with the state statute?
I'm saying it doesn't apply. So
Are you saying the state statute trumps the other statute?
the later enacted short-term rental ordinances of Metro is preempted
By the TCA?
by 137601.
Is that statute is that in the packet? Do you have a copy of that statute?
Yeah,
Okay.
it should be in your packet. I submitted it with my letter. This
Okay.
case has been deferred a few times, Mr. Pepper. But the exact provision,
Yeah, Mr. Collins just told me it's Exhibit 6 of the packet.
Okay.
So is there an expiration date on the original permit that was issued?
I don't know what that means.
Handle that question if it would be of help. All permits are 1 year in duration and must be renewed on an annual basis. This particular permit was timely renewed on a regular basis after its initial issuance in 2015, well within the 365-day period as required. It was only during one of those renewal submissions that we recognized that at a prior date there had been a change in ownership, hence prompting the cancellation letter sent by my hand earlier in 2018. I think that's probably also documentation that Mr. Holland has submitted with his case file, but there's no contention that these folks have failed to attempt to renew in a timely manner, have succeeded in doing so in the past, only that we on the staff level had failed to catch the change in ownership from 2015 that had taken place shortly after the issuance of the short-term rental permit, early in the short-term rental permit scheme history in 2015. Maybe worthy to note also, Mr. Chairman, as the question seems to be percolating, Ordinance BL 2014-951, which is the original short-term rental ordinance here in Metro Nashville, which was, I think the effective date on that is February 26 of 2015, includes the exact language that Ms. Lamb referred to earlier, which has been captured in every ordinance 492, 608 along the way, regarding the ownership change, or, sorry, I'll read from the original iteration, which was not even under the zoning code at the time, as you may recall, but instead under the business regulation section of the Metropolitan Code of Laws, Section 6. 628.030 subsection C as in cat reads in its entirety, no person or entity shall operate an STRP or advertise a residential property for use as a STRP without the owner of the property first having obtained a STRP permit issued by the Department of Codes Administration. You'll find that language to be completely unchanged in the further iterations of the short-term rental regulation, most recently codified locally by Council Bill number 608, as we refer to it in shorthand. Just in case that helps add any light to your consideration of the interplay between the state and local laws.
Now, I understand that obviously state law, supersedes our federal, our city law, but only when there's a conflict. Does this conflict with anything in the state ordinance, just saying the owner shall get a permit?
We do not believe that it does.
Well, and Mr. Holland is correct. The state law does say that the ordinance in effect at the time the permit was issued would be the ordinance that applies to that particular permit. But as Mr. Michael just pointed out, the ordinance in effect at the time the permit was issued stated that an STRP could not be advertised or operated without the owner of the property obtaining the permit. So the law that we are relying on and applying in this case has been consistently present in every iteration of the short-term rental ordinance.
Okay, so Mr. Holland, it said that in the state statute. You left that little part out, so respond to that.
I don't think I understand, because 250U was not in 951. So you lost me at least by half.
The two sections of law that are in play that led to the cancellation of the permit have been in existence since the original bill, 2014-951, the language of those two sections. Though it has moved sections within the Metropolitan Code of Laws, the language has remained the same during that transition of sections.
And that's on the transferability of the permit.
The second of the two sections is, yes. The requirement that an owner obtain an STRP permit before any operation is the first of those two sections.
I mean, there's not an allegation here that she was operating prior to the issuance of the permit, is there?
Not that I'm aware of.
You were here because of the transfer of ownership, Mr.
Right.
Holland. That's what's on our agenda, and that's why we're here.
Well, it got brought up. That's why I asked, Mr. Chairman.
Yes. So how do you respond to Mr. Pepper?
I'm still not finding a copy of the statute in the materials. I mean, maybe my technological incompetence.
137603 A and B.
Right. What I'm looking for is just to take a look, lay my eyes on the full statute there.
I understand. And I guess my presentation becomes a part of this record. But I apologize if I did not include it in my actual papers that I filed. What was your question, Mr. Chairman? I apologize.
How do you square what you said that the law does not apply because it was passed on that date with what John Michael said, that basically that is included in the state law, that the owner of any short-term rental has to obtain a permit.
So the owner of the property, so what happened, Mr. Chairman, there was a quitclaim deed.
I understand all that, and you're going to say it changed from here to here to here, but what our statute says, the owner has to obtain a permit, and if the owner, as it changed hands and names, didn't go get a permit.
The person with the permit today, absent the revocation, is the person that had it before, and her name is Grace.
Who had it in between?
Her name is Grace Jew.
Who had it in between?
She did. She was the operator of the short-term rental pre-quitclaim and post-quitclaim.
So where did it go?
All during, and all points in between.
Well, follow us through this chain of...
Who did the property get sold to, and who owned it?
There was no sale.
Then why are you here, Mr. Holland, if there was no sale?
It was
If it was all in the same ownership, you wouldn't
It was
be
a
here.
quitclaim
To
to a
who?
trust.
Ah, a trust.
But the quitclaim changes ownership. You concede that, right? I mean, even though there's not a sale, it does change the status of the owner of the property.
I would say yes.
Okay.
And then when she found out about it in the timeline, I think she's myriad of conversations back and forth between her and John Michael and staff. To show it wasn't an arm's length transaction or anything of sort, she quitclaimed it back to herself and eliminated
But
the
then at
trust.
that time, it was up to her to go get a permit because it had changed hands. By our law, it says any owner of a short-term permit,
What are you citing to me, Mr. Chairman?
what John Michael just read. Read that again.
Originally from ordinance 951, that was section 6.28.030C, language that was maintained through Council Bill 492, and then updated again in Council Bill 2017-608, codified there at 1716.070U, subsection 1, which operates the same language there. No person or entity shall operate a STRP or advertise a residential property for use as a STRP without the owner of the property having first obtained a STRP permit issued by the Department of Codes Administration in accordance with the provisions of this chapter.
So what is the legal ramification of it transferring to the owner of the STRP to another entity or owner? What happens to that permit?
We regard it as being effectively a termination of the existing short-term rental permit on the date that the transaction is completed. As shown in our records, that is apparently July 18, 2015. This is the transaction that Mr. Holland referred to as a quitclaim transaction to an entity called the Eric and Jeffrey Family Trust.
So that's
By
a different
operation of
ownership.
law, that was the effect.
So
even
the
though our
trust
letter
is
came
a
later.
different ownership than Grace.
That is correct.
And then if Grace gets it back from the trust,
That too is a change in
it's
ownership.
a change of ownership, and she just can't say, well, I used to have a permit and therefore I'm fine. As you read, any person operating a short-term rental permit, a short-term rental has to go get a permit. So she would, under our laws, need to go get a permit even if she previously had one because of the change of ownership.
I think you've got it right. If there were 5 changes in ownership, each of those 5 transactions would yield the need for the new ownership entity to send someone in and obtain a short-term rental permit if they intended to operate.
Okay,
I
Mr.
take it the reason that we're here with this type of appeal is that this, and I don't think we've had testimony, but it sure does appear that this is a non-owner occupied home in an area that doesn't allow non-owner occupied homes today, or otherwise we just say, when can you go apply again, right?
Right. You theoretically, the property owner could come apply for a permit later today if they wished, and it's just a matter of what the eligibility criteria is. Now, I'll save Mr. Holland a little bit of explanation on this because I think it's what he would say next, and that is that because there has been a permit legally and properly issued at this property in 2015 during the period when BL 2014, whatever the number was, 381, or 951 rather, was in application, that is the law under which this property owner would be able to come in and apply for a short-term rental permit. Now, that may assist them in terms of their eligibility, i.e. R and RS zoning districts did not necessarily ban what we then call Type 2 or non-owner occupied permits. And that is a protection that's afforded to property owners under the state law to which Mr. Holland referred earlier today. It's probably worthy of note that even to the limited extent the board might be inclined to see this as a potentially complicated issue of interpreting the legislation here at the local level, kind of one of the classic rules of statutory or legislative interpretation in the event of any vagary is to look to legislative intent. You have a letter in your case packet from the council member, Berkeley Allen, not only the council member for this district, but as you all know, the individual council member who was considered kind of the lead sponsor of the original legislation and subsequent legislation regarding short-term rentals. She expresses what her intent was with regard to this issue on the legislation. So to the extent that the board doesn't think that the law is straightforward enough in terms of how to apply the law to the facts of this and other similarly situated cases, you would then look potentially to legislative intent as one of the clarifying points, and you have an overt expression of that intent from the district council member. So I would encourage you to refer to those items in your packet as well.
So if we upheld the zoning administrator and said the revocation was appropriate, what rights outside of that action would the homeowner have to apply for a permit that only if they were an owner occupied? Would the homeowner then say, well, hey, this is my home and I'm applying for a completely different permit? I'm not worried about the...
Well, if I follow your question, Mr. Vice Chairman, the answer is they can come apply for a permit later today or tomorrow if they can get in to see staff and make that application. The law that will govern their eligibility for a permit, the local law that will govern, will be the one that was in effect when they originally obtained their properly issued permit, which was back in 2015 and was our original law, which didn't have those same restrictions that Council Bill 608 has regarding non-owner occupied permits in R and RS zone districts.
So that's what happens if we uphold the zoning administrator?
Yes. I think I've said that
Kind of
correctly.
makes me want to know why we're here.
All right.
Can I ask that same question?
Let me clarify then. And I've said, there's three criteria whereby somebody cannot come in and enjoy the protections of the law that was in effect at the time. And those three sections, or those three criteria under state law is if there's been a 3 strikes violation for bad actor stuff, which is presently unprecedented under the state law governance here in Metro. The second is a cessation of a legally nonconforming use for 30 months or more, that being consistent with the traditional grandfathering laws under 13.7.208 for commercial uses. And the third is for a change in ownership. So, circling back a little more detail there, because the issue is change in ownership, they would not enjoy under state law the protection that would allow them to apply under the then applicable law from 2015, but instead would have to apply under whatever our current law is, and the current law, of course, is 2017-608, which would not allow the issuance of a non-owner occupied permit in a R or RS zone.
So if we upheld the zoning administrator, the applicant would absolutely be eligible to apply for an owner occupied permit if that owner actually occupied that home?
If it's an R or RS zoning district. Council, I'm sorry, I don't recall offhand what the zoning district is.
It's RS.
It's RS.
But because
Okay.
the applicant chose to transfer the property to a trust and then back because of that transaction, however unlucky that might have been, were we to uphold the zoning administrator, that would keep this applicant from applying for the permit that they've had for
the non-owner
had for a
occupied
couple of
permit.
years till July.
So I'd like to firm up that timeline a little bit. So Grace owned the property and had the permit, transferred to a trust and back. So when in that timeline was the permit revoked?
The revocation letter was dated July 16, 2018.
And what was the status of who owned the property at that time?
The trust.
Was that the trust or was that back in?
The quit claim to the trust was July 18, 2015. So 3 years,
The trust still had it at that time.
right.
And she has since transferred it back.
On August 16, 2018.
And when she first bought,
Before I was hired, through her communication with John Michael.
but when she first applied for the permit in April of 15, the laws would allow this to be a non-owner occupied rental. When she sold the property to a trust in July, the law had changed. Right, right? I mean, the first time she transferred it to the trust, the new law had already taken impact, right? It had taken effect. Because I think in your notes it was maybe July 1st or was it the 31st? I can't.
What was the law in effect at July 2015? Is that your question?
Yeah, I think that you had said.
I think that's 951.
2014, 951 was the council bill, and that was our original law.
Well, but yeah. Well, but I think in the first page of your letter, you say you will begin enforcing the provisions of the ordinance on July 1st, 2015. So the July 18th, 2015.
So 951 had what I would submit as a delayed effective date.
Right, but
It passed sometime before July 1, and the effective date of the ordinance. was-
right. I'm just saying, but when the quit claim deed was transferred on July 18th, 2015, the new rule had already taken effect.
I agree. But not, I understand where you're going with that, but the operative effect of the ordinance pursuant to the Short-Term Rental Unit Act is when you started using your property as a short-term rental, holding it out to the public, not.
But the only question here is who's you, and is it Grace, or is it Grace's trust, and is that the same or not the same? And I think that's what that ultimately is it. So I know what you're arguing is it's all the same, and what we're hearing now is it's not.
Right,
so,
because if I brought Grace Trust in here, it'd be Grace, and if I brought Grace in here, it would be Grace.
Right.
Yeah, same people.
But
That's what you're hanging your hat on, that they're the same. Okay,
Right.
you concede the transfers, you're just saying it's, the transfers, is it as if they didn't happen because it's the same entity, right?
For the purposes of perfecting an appeal along the way, regrettably, yes, I do. But I'm saying.
is a trust different from an LLC? Because if it was a single member LLC, would that be the same? Because I think the law specifically says you can't do that.
I don't see how can I finish there?
Yeah.
And come back to you? I'm sorry. I don't see how the benefit of a trust, I think, is to avoid probate. I don't think seeking to avoid probate is tantamount to a arm's length transaction between me and you. I don't equate those as being the same.
But I think the law does. I mean, the law regards a trust as a separate entity. And there are things advantages besides probate, right? It's a way to protect assets.
I'm not an estate
Right.
planning attorney, but I know that's one obvious benefit.
Yeah, no, I get what you're saying, but I think legally they are separate. I mean, that's pretty clear to me. A trust is a separate entity from a person.
And so the prohibition of the enabling ordinance, 951, was on the transfer of the permit. And I'm saying, because the ordinance does a couple things. It says, well, if you do something, you get the 3-year ban. If you're in general sessions court, you get a 3-year ban. The ordinance says it runs with the land. Well, these permits don't run with the land.
What ordinance says it runs with the land?
608.
601?
608.
Okay.
So the prohibition, obviously, I don't think anybody could pass a law, Metro Council or otherwise anywhere else in this county or the state could pass a law that would ban the transferability of property.
Sure.
I think we can all agree on that.
Oh, yeah.
And here, the point or the language, you don't need to get into anybody's intent, especially not post-adopted intent, but the language says that the permit shall not be transferred or assigned to another individual. And there hasn't been one. There hasn't been an attempt at one.
So how did she maintain once that land was sold, then why did that not immediately invalidate her permit? She didn't have, did she have a lease with the trust? I mean, how did the trust allow her to continue using the property? I mean, it seems like as soon as that transfer happens, she doesn't have the right to that permit because she doesn't own the property. I mean, the trust would have to go get a permit.
Well, who would make that application for the trust?
The trustee,
I mean, which is
right.
great.
Yeah, but she would be doing it as a trustee as opposed to an individual.
And there were other family members in this trust. It wasn't just her.
Well, this is for the benefit of her children.
There's other family members.
Yeah, I mean, the properties, the Shushu Dean also was one of the property owners. And, for me, being able to quit claim it with a Tennessee title attorney, quit claim it over here and then quit claim it back, that tells me that, do we really have a transaction there?
Mr. Holland, we are not the legislative body. The legislature of this Metro Council, and I think the state legislature, was very clear when they passed these two bills. Now, if you have a problem with those laws, I would take that up to the Metro
I
Council.
don't have a problem with those laws.
So
Mr.
you were saying
Chairman.
that, saying that because it was so fast that there might be legitimacy of the power of the trust or something, or is that?
I'm saying there's not if you can do it that easily, that quickly, then it's all the same person. It's not a adversary or an arm's length transaction or some third party. It's, you're doing it with yourself. These are transactions with yourself.
But it's a change of ownership when it goes to the trust. That's what Mr. Pepper
Yeah.
said. He's a real estate lawyer. He knows this stuff. When you give it to a trust, that's a different owner.
Right, you never see a deed from Ross Pepper to Ross Pepper. That would be pointless. That's a superfluous transaction.
Right.
So you're always using a deed to transfer from one person to another person or one person to an entity. I understand what the argument you're trying to make. I think your dilemma is that when you have a trust, you got to take the good with the bad, right? I mean, there's tax advantages and there's other advantages, but part of that is you also accept that it's a separate legal entity.
So what happens if someone is added to a deed and thus the property owner is no longer an individual but is now two people? Is that a reason for revocation of the permit?
Mr. Harper, to the extent that question is directed to staff, yes.
It's a change of ownership.
So everybody that has a STRP permit of any type that gets married?
Marriages and divorces are the one category of caveat where we've tried to work with people because for Pete's sake, it's hard enough as it is getting married or getting divorced. Forgive my frankness. I stand by that and will say as much in court if need be. That said, changes in ownership that we see on a regular basis may be adding adult children to a deed, may be adding a business partner to share in the financial liability risk.
And John Michael, I think in that case, there's a difference between, and you could argue whether divorce or marriage is voluntary or involuntary, but voluntary transfer of ownership versus involuntary transfer of ownership, which would possibly happen because you got married or divorced.
So is there anybody besides individuals that can have an STRP?
Husband and wife or couples or co-owners who are owner-occupied property owners, the fact that it is multiple individuals on an ownership deed is not necessarily prohibitive of an owner-occupied permit.
But can a trust?
Pursuant to Council Bill 608 and the Natural Persons Amendment, no. A trust cannot be the holder of a short-term rental, owner-occupied short-term rental permit if it's a new permit application, nor can an LLC, nor can a other corporate entity. It's got to be David Harper, not the Harper Family Trust, not Harper Realty LLC, or other such examples of.
They are allowed to own non-owner occupied.
That is correct. And the only clarification I have to give there is that's in terms of new permit applications.
Yeah.
There are plenty of examples on the books of owner-occupied permits held by non-natural persons previously. They're considered legally non-conforming in that regard. However, as for a new application, only a natural person is eligible for an owner-occupied permit under the existing state of the law.
trying not to cloud the water, I'm actually trying to split the hairs down logically here. So this is a non-owner occupied, or was, permit, correct? And that was allowed originally. And it was revoked once it had become clear that it was now a different, or was interpreted to be a different owner. And at that point, the law had changed. Do I have my timeline here?
The law had actually changed when the ownership changed. The law went into effect July 1, 2015. They changed ownerships on July 18th, 2015. And it was not caught until July of 2018, so they got 2 years of benefit from the short-term, non-owner occupied short-term rental until July. But at the time that the ownership changed, the new law had taken effect.
And so, I guess my question to staff or to our attorney is, would they have been grandfathered had everybody known what was going on at the time?
Mr. Harper, with respect to the law change, the crux of the requirement here is that the owner of a property must obtain a permit. So that particular section of the law has never changed. That has been included in every iteration of the ordinance. So per state law, yes, a permit operates, or property operates under the law that was in effect at the time the permit was obtained.
So,
But again, regardless of when the permit was obtained, every single ordinance that has ever been in effect for short-term rental has
Well,
required the owner of a property to come in and obtain a
right,
permit.
okay, I guess what I'm asking is, had everybody known the situation of the transfer and all of that, and they had walked in and you realized that it had changed, or the staff had realized that it had changed, would they have gotten the permit?
The trust would have been eligible for the permit upon acquisition of the property. I believe that acquisition date was July 18 of 2015. The trust, I believe, would have been eligible at that time for a Type 2 permit because it predated, or Type 1 for that matter, because it predated the Natural Persons Amendment, which took effect more recently.
Is Metro arguing that only because we didn't catch it till now, they do not enjoy that grandfathering?
We make no such argument because it's not an issue before the board. What's the issue before the board? It's whether or not there was a change in ownership and whether or not that is an appropriate basis for cancellation.
Well, I guess what I'm asking is, if they had come in, at some point, if everybody had known, if everything had been done by the book, would there have been a problem with them getting a permit when that permit was to be renewed, or should they have come in at a date pre the renewal date?
Probably not, and there are a number of ways to, borrowing your phrase, go by the book. Don't change ownership. Keep on cooking, renew on a timely basis, keep your permit. Change ownership, have new ownership come in and make application for and obtain the permit, which seems to have been an eligible scenario in July of 2015.
And that is the way to do it. If ownership changes, if your permit is, you're to renew it January 1st and your ownership changes November 15th, you should go in November 15th and renew?
November 15th, because that change in ownership is, by operation of law, cancels the previously existing permit.
And is there any evidence that, did the trust ever have their name on a permit, or was it always?
I believe, and the counsel for the appellant
appellant.
may be able to speak to this more conclusively than I can. I don't believe there was ever any change of the name on the permit.
Okay, well, that would have triggered something too, if you wanted to change the name probably.
Change of the name would have been seen as an attempt to transfer the permit and would have required a application for a new permit.
Okay.
And board members, we have an email in here from Councilman Bob Mendez who, and I'll read it to you. He says, "I'm pretty sure that I authored the language prohibiting the transfer of the permit from one owner to the next. I know I was present for all or nearly all the council debate on this topic. As drafted, I did not intend for there to be exceptions to this rule for any purposes. The intent was to have a fair phase out of STRPs in traditional neighborhoods zoned as residential while allowing existing property owners who bought under the old law to continue to operate as an STR until they sold the property." And then he goes on to say at the end, I would argue that the BZA should view the situation as one where the Metro Code does not allow any exceptions, and the variance should be denied. Not a variant, but we get his point. Councilman Mendez very frequently on his blog explains how he voted on something and why, as does Councilman Sledge and Councilman O'Connell, but he is usually in a lot of detail, just like this letter. And since he was the one, along with Council Lady Allen, that really were behind this ordinance and this language, I think that is very telling on people saying, well, why does it matter if it goes from one to another? As he said, he wanted to kind of phase them out, and when the old owners dropped out, you kind of lost that privilege.
Was the property actually sold?
No.
It was transferred, though, to this trust. And I'll ask
that
our real
constitute a
estate,
sale?
well, let's ask our newest board member and real estate expert. When it goes to a trust, legally, what does that mean?
Well, it goes to a separate entity. I mean, that's,
But is it a different ownership? I think that's.
it
what
is
he was
different
saying.
ownership, yeah, it's totally different ownership.
Is there a
And I get
transfer of
Mr.
money?
Holland, what's that?
Is there a transfer of money? Is there?
Well,
is
even
it
if,
sold?
but the ownership doesn't depend, you can have a change of ownership without there being any transfer of money. I think that's the touchstone is there a transfer of ownership? And if it goes to a trust, then there's a transfer of ownership, so.
Going back to 628-030C, just want to read that in the record. No person or entity shall operate a STRP or advertise a residential property for use as a STRP without the owner of the property having first obtained a permit by the Department of Codes Administration. And then P, permit shall not be transferred or assigned to any other individual. My point again is, and I got more time than I thought, because Jessica's not running that clock, but
We don't run it when we ask questions, Mr. Holland, you know.
the transferability is limited to the permit. Number two, 951, I submit the effective date of that is July 1, 2015. And she began using her property as a short-term rental predating that. And this is an alternative argument for the purposes of the record, because I don't want to waive it. But I would submit that 951 doesn't apply, and she operates her property as a short-term rental predating any ordinance. And pending your questions, Mr. Chairman, that concludes my comments.
Okay. Any other questions? John Michael.
Mr. Chairman, on that point, I think it's important to note Mr. Hollins correctly identified July 1, 2015 as the date of the effective enforcement of the provisions. The exact language, Department of Codes Administration shall begin accepting STRP applications on March 31, 2015. You may recall the lines wrapped around the building for several months to obtain those permits. Lord knows we do. And shall begin enforcing the provisions of this ordinance from and after July 1, 2015. Enforcement, of course, comes from our Property Standards Division, and they did not send out any enforcement notices or take any requests for service until after July 1, 2015. That was the enforcement in question and as applied.
Okay. Any other questions for Mr. Holland?
I guess one more, Mr. Chairman, I apologize.
Sure.
Can't have dual effective dates. And also, I think the PJ and Pamela Anderson case, and this is a unique situation, ruled 951 unconstitutionally vague, therefore the council came up with 492. So that's just another layer of consideration.
Okay. We'll close the public hearing. Discussion. I have a question for John Michael. He mentioned about the court case and the intentionally vague. That got changed or overturned or dropped.
The one provision that the circuit court judge had identified was absence of a sufficient degree of differentiation between hotel and this particular use. That has since been amended under the zoning code, and that was that.
Okay. So discussion. One of the things, and we have a real estate expert here as a lawyer, and I'm waiting to hear from him again during this deliberation, but if you take a piece of real property that's, considerably valuable as this one was, you don't do it just kind of on a whim. You do it with the advice, and I think most people don't kind of sit in their house and think, hey, let me put this in an LLC or put this in a trust. You do that at the advice of professionals, accountants, lawyers, and other professionals. So this was not done without somebody drafting documents and having things signed and notarized. So these same professionals should have been up to the legal ramification of what this transfer would be, and they weren't. And like I said, when you use professionals, you should know that there might be some other consequences.
Yeah, I mean, I think it may just be a flat-out sad, honest mistake, you know? I mean, I don't, you know, I think there probably are, you know, folks that, you know, I think we probably even heard folks that had, you know, said, oh, well, it's going to limit my liability. I'm going to put it in a LLC, and the next thing you know, they are in trouble with their permit because they just didn't know, and the accountant, you know, and you know, may not have had a clue about, you know, short-term rental rules. But that said, I think that, to me, the underlying issue is what you said. I mean, it was transferred, and, you know, I think that Codes has been consistent in the way they apply the rules from the beginning, and I don't see, you know, there may be an argument to be made, you know, at a different level than this board, but at least I don't, and maybe not. I mean, but I don't see where the zoning administrator erred. I guess that's my bottom line. I don't think there was any intent by the applicant to lose their short-term rental permit by changing ownership, and I doubt that they would have done it had they known, because they reversed it as soon as they could, or as soon as they realized it was a problem. But based on what we hear from our new board member and others, I mean, an ownership change did happen, and that's how our code staff has always interpreted this rule, and I don't think it's incorrect.
Any other discussion?
I think the zoning administrator has it correct, and I think that I get the argument. I understand that a trust sometimes is, it's really, it's not a person, and it's almost like the person, but we'd have to ignore hundreds of years of law about that. I mean, a trust is a separate entity, and if you, that's the reason there's been transfers of ownership, because they are different entities, so it's kind of a self-proving thing, so.
Does anyone, yes?
Well, I was just going to say, I think the ordinance in effect at the time that applies is 951, because it was effective prior to the enforcement date. It precluded the transfer of ownership that occurred, and regardless of the reason that it occurred, it clearly was prohibited, and I don't see that the zoning administrator erred.
Okay. Any more discussion, or someone have a motion?
I'll make that a motion.
Okay,
That the zoning administrator did not err. 951 did apply in this situation. It was in effect at the time the permit was issued. It prohibited a transfer of ownership which occurred during the permit period, and therefore the permit should have been canceled.
okay.
And specifically, if there's questions, it was enforced prior to the property transfer. I mean, it was in effect, but it also was, the enforcement date 7/1/2015, so even under both.
Sure. Yes, it was after the delayed enforcement period went into effect on July 1/15. The transfer occurred.
So not only was the law in effect, but it was.
Okay, you're in agreement to that for your motion?
Yes.
Okay. Motion's been made, is there a second?
I'll second.
Motion's been made and properly seconded. Discussion. Seeing none, all those in favor of the motion signify by saying aye. Aye. Opposed?
Because I did not hear the argument.
Okay. So 6 in favor, oh, and against? Okay, so 5 in favor, 1 against, 1 abstention. So, next case. Emily.
The next case for consideration by the board is item number 2015-658, Robin Perry is the appellant and owner of the property located at 5533 Tallman Drive, which is shown here on the aerial map. Mr. Osborne is here again with the presentation of this case for staff. There being no one here in opposition to this case, Ms. Perry, after Mr. Osborne's presentation, you'll have 5 minutes to present your case to the board.
We found out about this through host compliance. On October 5th, 2018, we sent a notice. We did receive 2 complaints about the property operating without a permit. One was in September 19th, and the other one was on October 9th. There were about 20 rentals from July to October 2018. The advertisement was removed around October 15th.
Did any of the complaints have anything to do with behavior, just the fact that they were operating without a permit?
That is correct.
Okay.
Okay. Any questions for Mr. Osborne? Thank you. Please state your name, your address, and why we're here.
Good afternoon. My name's Robin Perry, owner of 5533 Thalman Drive, Brentwood, Tennessee.
Okay. So you rented without a permit. How did that happen?
Yes, sir. I made the mistake but take ownership. My daughter, who was 24, set up the Airbnb.
And how did that conversation go? Did you know what Airbnb was?
I was aware of it, and I have a girlfriend in Florida who operates a Airbnb, excuse me, and she never mentioned that you need a permit, and I think in the state of Florida you do not need a permit.
So she said, hey, why don't we do this? How much convincing did you need, and how did you get from a conversation to actually renting your home out?
Well, I've had a change of employment, and my income went down drastically when I've lost some jobs in the last few years. And Alexandra had mentioned how well her boss was doing with her Airbnb.
Was this in Nashville?
This was in Franklin.
Oh.
And so then I spoke to her and said, honey, you know, why didn't you tell me that there was a permit involved? And she said, well, Leah never mentioned she needed a permit, but obviously Leah does have a permit, but she did not exchange that information to my daughter. But I take responsibility because I'm the owner, and
So when did you first,
yes, I live in and I own it.
so when did you find out we had laws and that you were in violation of those
Okay,
laws?
we set up the Airbnb in July. I received the letter in October. I received the letter on Saturday. I forget the date in October, but I called Mr. Osborne's office first thing on Monday, very upset. Oh my God, my daughter, you know, we talked about doing this, and I trusted that she knew what was going on, being 24 and being a college student. I made a mistake, but yet I'm responsible for the house. So I contacted Airbnb right away and said, oh my God, you know, I'm in trouble. I didn't know about the permit. Cancel all my reservations.
How many did you cancel?
I had reservations that were booked all the way up until June. So we canceled them, they canceled
So
Airbnb.
how many?
How many? Probably 30 or 40.
30 or 40? Oh.
And they did not charge me. They said, you know, we're gonna take care of this. And then I said, look, I did not know about the permit. I don't want other people to find out about this. Please do something for the state of Tennessee when you apply for Airbnb and say, by the way.
If you put in a zip code, something should pop up and say,
Right, I
hey,
just
your
said this-
municipality has laws. Go contact them before you do
I said
something."
this would be very helpful because I didn't know. I'm in my 50s, I'm responsible, and I feel like an idiot not knowing the laws and having to go through all this, and I just, excuse me, don't want other people that don't know to have to go through this. So I talked with Airbnb like 3 times.
And what did they say? Because we have told Airbnb and their representatives here locally that that would be an easy thing to do when you put in an address or a zip
Right.
code for something to pop up and say, you need a permit before, or you have to enter in a physical number. What did they say to you?
He said, well, thank you for the suggestion, Ms. Perry. I will take it up with, you know, higher management. And I just said, well, I hope you do this and just don't say it because you're going to have a lot of phone calls in a lot of cases because this is, you know, this is what's happening in Tennessee.
Yes, okay.
And do you stay in your home when your guests are there? Do they?
Oh, yes, that's my only home. that's my only residence.
Okay.
So,
And what was the last day that you rented the property, do you know?
it was when I received that letter, so it was around October 9th or October 10th.
Okay.
So as you know, we have a small but very capable staff that looks into violations, and Mr. Osborne knows when you are sleeping and knows when you are awake, knows if you've been bad or good or don't have a permit. And he will find out who is naughty and nice. So we are here to deal with this. So
Right.
what have you learned from this whole procedure?
Well, I've learned for any ventures in the future not to have my daughter say, hey, Mom, this is a good idea. It's like, I've learned my lesson with that, and to investigate and get all the information on the upper hand before.
Because we have a website that you could find out all that information at nashville.gov in the short-term rental part. We could talk about our laws, or if you Google Nashville short-term rental permits, I'm sure there's a bunch of stuff there too. So, any questions for the applicant? Okay, thank you for being here. Let's close the public hearing. Discussion.
I mean, this seems to be one of those cases where someone didn't know. As soon as they did know, they did the right thing, canceled an awful lot of bookings all the way through next year. Definitely applaud the applicant for that and doing right. And I think this is in that kind of lower quadrant of penalties of someone who did the right thing once they found out that that's what they needed to do. So I'm not sure what date you all are thinking. If it, I'm thinking between now and the first of the year, being eligible 2 to 3 months. Is that,
Why don't you make us a motion? When was the last date that it was rented?
the last date it was rented was
October?
October 15th
Okay.
or October 9th. I'll move that the zoning administrator did not err and that the applicant is eligible to apply for a permit on January 2nd.
Okay, motion's been made. Is there a second?
Second.
Motion's been made and properly seconded. Any discussion?
Well, just for the record, I'd like to say that when I was 24 and I didn't do anything, so just for future reference. I know now I didn't do anything. I thought I knew it all.
But did your mother listen to you?
No.
She's my only daughter, and like I said, I apologize. I take ownership. I was trying to let her be an adult, and so it's still a learning process
Okay.
being a mom at her 24.
Yes, very good. All those in favor of the motion signify by saying aye. Aye. Opposed? Passes unanimously. Good luck. Follow the rules. Okay, Emily.
The next case for the board's consideration is item number 2018-669. I'm sorry, 661. Grover Collins is the appellant on behalf of Kevin Kwong, owner of the property located at 1102A Joseph Avenue, which is shown here on the aerial map. This appeal is challenging the cancellation of a short-term rental permit issued to Mr. Kwong. The permit was canceled because the zoning in this particular property, on this particular property, does not allow short-term rentals, so therefore the permit was issued in error. This property is zoned SP. Section 1708030 of the zoning codes is the land use table, and it allows short-term rentals in SP districts only if the specific SP ordinance allows it. So SP means specific plan, and that is when a property is zoned SP, the SP is created particular to that property, or perhaps a cluster of properties, and that ordinance is what affects those particular properties. And again, 1708030 says that short-term rentals are only allowed in an SP district if the SP specifically allows it, because they're all individualized. In this case, the SP ordinance was very specific regarding the uses. Section 3 of that bill stated, "Be it further enacted that the uses of this SP shall be limited to one single-family dwelling or a detached two-family dwelling." Single-family and two-family dwellings, those are separate uses in the zoning table, or the land use table rather. And short-term rentals are a different use. So you've got single-family and two-family and short-term rentals. Those are three different uses in the zoning, in the land use table in the zoning code. Single-family and two-family are allowed. Short-term rentals are not allowed in this particular SP because they were not specifically listed in the SP. Mr. Collins is here on behalf of the appellant and the property owner. He will present their arguments for the board. There being no one present in opposition to this, Mr. Collins, you'll have 5 minutes to present your case before the board.
Thank you. Thank you, Mr. Chairman. My name is Grover Collins with Collins Legal, 414 Union Street, Suite 1110, Nashville, Tennessee, 37219. I'm here representing Mr. Kevin Kwong, who is the resident and owner of 1102A Joseph Avenue in Nashville, Tennessee. I'm going to get right to where we're at with the procedure to save you all some time. I've provided the packet with everything that we have, but I would turn your attention to page 2 for the summary of the proceedings below so that we can kind of
Have your brief, though, too. Thank you.
to kind of get to where we are as far as the timeline. On September 30th, 2015 is when Mr. Kwong initially got his permit. As we learned in the first one where Mr. Holland was representing, 951 would have been the applicable bill at the time. When 951 was passed, also BL 2014-909, which I failed to put in the packet, but 951 is provided as Exhibit 7 to this packet, as well as the state statute 13, TCA 13-1-601, that's Exhibit 6. If you read 909, Section 3 of 909 that was passed at the same time with the effective date to correspond with 951, it says, and I quote Section 3, Section 17.16.250 of the Metro Code is hereby amended by adding the following provision as subsection E, in quotation marks, short-term rental STRP is permitted as an accessory use in all zoning districts that allow residential use, provided a permit has been issued for the operation of the property as a STRP pursuant to 6.28.030. The issue that Mr. Kwong has and the issue that I have in the other SPs that I've brought before this board is Mr. Kwong got his permit in 15. He invested significant money in order to operate and have that as a non-owner occupied permit, and he continued to renew that permit. He continued to rely on Metro telling them that he could. He did everything he could, and when he finally made application to renew for the 2019 period, that's when he was instructed or told, and you'll see the email correspondence as Exhibit 1, that, oh, now we made an error, and therefore you can no longer have a permit. Now, I'm aware the city would rely on the CAPS case pretty predominantly, but I want to make a very small distinction that I think has a very large impact. In the CAPS case, and if you're unfamiliar, CAPS versus Metro Government is where an adult entertainment facility went in next to or was going to go in next to the Nashville Rescue Mission. They were granted a permit on the 21st of July. On the 27th of July, an appeal was made by the Nashville Rescue Mission. That adult entertainment facility continued to build, continued to do all these things, knowing that there was an appeal that was going on. They basically ignored what was happening. This is not the case. We have a situation where we're telling people, this is fine, you can do this, you're following the law, good job. We're going year after year after year and telling them, this is fine, keep operating, we accept their taxes, we do everything that it is allowed. The Metro government gets the benefit of all the tax money. And now only after they substantially invest and make decisions based on having this permit, do they now say, hey, you can't have it. There's no transfer, there's no bad actions, there's no complaints. There's only the reliance by the property owner that Metro knew what they were doing when they issued the permit.
But the property had to be finished before they could get a permit, so what investment did they have? What investment specifically did they make after they got a permit and before it was canceled?
Furnishings and everything you would need to.
But they had to have that before they got a permit.
They wouldn't have had to have the furnishings there.
Well, did they have the furnishings before they got the
No,
permit?
they would have gotten the furnishings after that, because when they purchased the property, they were going to use it, much like my home would be different if I were going to use it as a rental to someone else. I would have very different furnishings and that thinking. Also, if I have a house, which I know is generating income as a rental as opposed to my primary residence, I'm going to make other decisions, as Mr. Kwong has with other investments, on down the road. It's a domino effect. And if we extend this out, if we allow the zoning administrator to say, oh, wait, we made a mistake, where does that end? If we make significant investments to a building or a commercial building, another residential, and then 3 years later, we say, hey, we made a mistake? Do we then tell that person they have to tear that building down, or they have to change completely?
So, but I guess why isn't that remedy in court instead of this board? Because it seems like this board's only question is, did the zoning administrator err? And if the zoning administrator, we say they didn't, it seems like that if there are remedies that you feel like are things that negatively impacted your client because of that, why would this board be the one to solve it for you instead of taking it to Chancery Court and say, hey, this has caused my client problems?
And it's a great question. But the thing that I always like to do before I go to a court is let the court know that I've exhausted every administrative remedy before I got there in order to see, hey, is this something we can work out and figure out before we take that next level? And as you may or may not very well know, the cost is significantly different at the next level. And
so are you saying that when your client put in this, I guess I'm confused on the timeline of, I mean, I understand it was 2015, but the SP at the time, you're saying that at the time he did that, all SPs were eligible to have a short-term rental permit?
I'm saying
I guess if that's true, then why didn't codes buy that? I mean, it always comes across as, I'll get something that's really obvious over here, and I'll get something that's really obvious over here, and I don't, but it sounds like, to me, you presented a timeline that's like, well, if all that's true, why are we here? So what part of that's being contested?
I think, and I don't want to speak for Metro Codes, but I will say that there are instances where there might be larger effect for more than one property. And I think when those instances arise, as this one may very well be, Metro Codes would like the direction of the board and whatever subsequent rulings for the direction on that, especially if it's maybe not apparent.
All right. Okay.
Obviously, it's apparent to me. I'm not advocating for my client, but
Right.
I hope that answers your question.
No, I get it.
But aren't we in the same position, or actually, aren't you better situated than the earlier argument if we find that
Yes.
the zoning, okay.
Except for, the only difference here is, this is a non-owner occupied permit. The SP does allow for single, as was read. 909 to me says all residential uses. There's be some disagreement as to whether that includes an SP or not. That's the disagreement. And then 951, in my opinion, would apply, and then we could have a non-owner occupied permit.
Right, but you go back to the 2015
That's
law.
correct. But what I'm saying is there's no reason to do that. We should just be able to reinstate the permit and continue moving on. It's a very different process if, there's another month of rental income or 2 months or however long it takes to get the fire inspector down there to approve.
I mean, that I do understand, and I don't think it's a perfect process, but at the same time, you're talking about potential loss of income, but you're not incurring additional, I'm going to use the word damages, not necessarily in the legal sense. I mean, the home is furnished, you've done what you're going to do, you have a clear path to obtain the relief you want other than this board, right?
I don't, and I'll defer to.
It's just quicker. You're saying today is quicker.
Not only that, I do not believe standing before, or sitting before this board today that codes would necessarily issue the permit. Because if they had, I would have not have had to appeal, because I've asked that question.
Okay.
And it wasn't issued.
All right.
And I don't know, I think the hard line from Metro Codes is it's SP no way, as I believe is the position today. So I guess to your point, I don't believe that I would be in the same position. I don't think they would grant the permit.
You don't think you can get a non-owner occupied?
That's correct.
Okay.
Even though I would submit to you that 951 and 909 would allow me. I think codes would like some direction from this board. And again, I don't mean to speak for codes, but on how that interpretation is going to roll out.
Okay, thank you.
So how does a client go about making investment decisions on a permit that only has a guarantee for a year? I mean, there's an assumption it may continue after that, but it may not. I mean.
Well, I think that was cleared up with the state law. I mean, with the enactment of the state law, as long as you do everything you're supposed to and you're a good actor, there's no reason you won't continually be able to renew that permit on a yearly basis.
You mentioned the taxes. Wouldn't taxes have had to have been paid anyway, or am I wrong about that?
Well, and maybe there is a separate tax for short-term rental
Short-term rental,
occupancy.
okay.
There's a per-night tax to Davidson County.
Gotcha, okay.
There's sales and use tax.
You're not talking about the property tax?
No,
obviously.
no.
Okay, gotcha, yeah.
Any other questions for Mr. Collins? Anything else to add? Okay, thank you. Let's close the public hearing. I do want to ask Mr. Lamb about his interpretation of this, the state law that he said all zoning districts that allow residential use, you can have this, so.
Sure, so if you look, there's a difference between residential use and residential zoning. So if you look at our land use table, it has, all the different uses that are allowed under the different zoning categories. So SP zoning, I believe Mr. Collins cited something that said the SP zoning district allows short-term rentals everywhere the use is, I can't remember exactly what the wording. 909. Well, so the issue here is that short-term rental is a separate use in Metro zoning table, in our zoning code under the land use table. Short-term rental, SP is a zoning district, and if you look under the zoning district of SP, short-term rentals are allowed as an accessory in residential areas, but it's not allowed in an SP under that zoning district unless that specific SP allows it. So it's not that we say, no way, this is SP, you don't get a short-term rental. We do this on a case-by-case basis. This particular property had a particular SP ordinance that governs that particular property, and that SP ordinance does not allow it as an accessory use or otherwise. It doesn't allow short-term rentals.
How does that not conflict with state law? Because the state law just talks about all zoning districts that allow residential use. I mean, yes, you get into this rabbit hole of, SB and these districts, but allowing residential use seems pretty clear to me.
Are you arguing there's a conflict with the state law?
We'll let Mr. Collins.
I know it closed, but
Yeah.
just so I'm very clear, BL 2014-909 was the one that said all residential uses. It was the Metro ordinance, not the state law.
Okay.
The state law is what then said, hey, because you gave it under this, because you gave them the permit under that zone, that zoning ordinance, then it moves forward. Does that
answer your question?
And again, just to clarify, it says that this is allowed as an accessory use in all zoning districts that allow residential uses. SP is a
doesn't
zoning
allow.
district that does not allow this particular use as an accessory use. So yes, according to 909, STRPs were allowed as an accessory in all zoning districts that allowed it. SP is a zoning district that does not necessarily allow it. You look at the individual SPs on a case-by-case basis, this particular SP did not allow it. If it had allowed it, it would have said single-family dwelling, two-family dwelling, and short-term rental use. It didn't. It stopped short. It said single-family dwelling or a detached two-family dwelling.
Okay, Counselor, how do you respond to that?
I would say that when we're talking about the creation of an SP, and we've talked about the amendment of an SP before, but we're talking about a situation where it wasn't yet a use when the SP was created. And it says that it's going to allow use in all zoning districts that allow residential use. Well, the SP specifically laid out the residential use, and now because it's laid out a residential use, which the SP allows the use, now we have the accessory as part of the use that's allowed under the SP.
I understand what you're saying. I think we talked about this before. What you're saying is when this SP was formed, short-term rentals were not an issue.
At least
That's
not codified
something
into it. That's correct.
They would have used. And
But now they are.
But now they are. But because of the state statute, we have to revert back to,
But does that mean all, now do we say all SPs, if you allowed a residential use and somebody comes in here, now that short-term rentals exist, is your argument that all SPs would allow it, whether they specifically say it or not?
I'm not making that argument today. I'm sure I will in the future. But today I'm arguing that because he got his permit in 2015, that is what applied to this SP as written.
So,
So I don't think there's far-reaching effect. I think it's limited to this.
and so the alleged mistake would be that, that Metro is claiming is that the permit was renewed after, much like the previous case, after the law said, no, you can't do it in SPs from now on.
There was a change in the way they interpreted the law. That's why you're gonna see a lot of these SPs. Planning and codes decided, we're looking at this the wrong way. And when they decided that we're looking at this the wrong way, they now say, anything that's SP that doesn't specifically say short-term rental, we're gonna disallow it and cancel them. And they created a spreadsheet, and they're gonna go through one by one and knock off the ones that have SP.
Okay.
And I'll stand before you
Is
for,
that, if the SP can be amended, I mean, that's avoidable, isn't it?
well, I mean,
I know that doesn't address your question today, but in looking forward,
an SP amendment is, it's not gonna happen. I mean, logically speaking, if a council person or anybody on the council right now would have to stand up and say, I basically support short-term rentals, and we all know that's not gonna happen.
Non-owner-occupied short-term.
Right, so, I mean, logically, no, there is no other option. An amendment is not an option for any savvy political candidate that wants to run again.
So, and I'm trying not to be redundant, but this wasn't caught at a typical renewal.
For the 15 was renewed, 16 was renewed, 17 was renewed for 18. When they tried to renew for 19 is when it was called.
Oh, I see.
Any other questions?
Well, but as I understand your argument, it's not just that it's okay now because it was issued in error and they kept renewing it. You're also relying on this state law.
Well, the ordinance state, yeah.
Okay.
And what the language, the specific language of this SP though, just says all residential uses. That's,
This SP specifically says, and I'll read it for you. I apologize, I had it right here. This one said, Section 3 says, be it further enacted that the uses of this SP shall be limited to single-family dwelling or detached two-family dwelling as the residential use. And I'll also make this board aware, if they're not already aware, if you are, I apologize, but these ordinances are passed, then the sketch goes through, and then the site plan goes through, and oftentimes the site plan has different uses on it or different things added, because it's a continual process with planning, and every single SP ordinance gives planning the option to make modifications. What they may have seen as minor in 2014, now is major as it relates to short-term rental.
Any other questions for the applicant? Okay, thanks. We're going to close the public hearing again. Discussion.
So this might be the hazard of having a novice on even though I've been on this board for 10 years, I'm not a lawyer, although I claim to be one. But I'm still confused as to how, and I know this isn't the crux of the argument, but that we renew it, and you know what, we shouldn't have renewed it. I don't understand how you get there. I don't know what the analysis is, and I know codes is swamped with permit applications of all kinds, but I don't understand how it just keeps flipping through and then suddenly it's discovered on SPs.
I mean, there is something that seems unfair about that. On one hand, had they caught it 3 years earlier, or 2 years earlier, they wouldn't have had the benefit of 2 additional years. But to me, there's something about, so I really want to ask our lawyers about it, because how do you, if the SP was created before the short-term rentals were a thing, how do you anticipate that, and, I mean, you didn't include it, but you also didn't explicitly exclude it. And, and I understand, if you created an SP after the short-term rental ordinance was passed and you didn't include it, then that absolutely signals that you don't want it there.
Well,
But I guess that's where I have and am I missing a timeline, or is there something?
I'd like to give my non-lawyer answer to that and see if I'm wrong, but to me, that seems like a classic case of legally non-conforming, that we, on almost any other issue, would accept and would continue to, or allow to continue. That's my take on as I'm understanding this case, and I would really like to know if I'm wrong.
I'll answer that. So there are two issues that I have heard brought up. One, with respect to why codes misses these. Codes, can you hear me now? Okay, so there are a couple issues that I heard brought up. One was the issue of why codes, why these come before the board when codes misses something or renew something when we shouldn't have. There are, I think, 12,000 to 13,000 permits that are issued by codes every year. There are currently 5,000 short-term rental permits that exist in Nashville. So proportionally, a handful come to you. It might seem like y'all are continuing to get, cases that were renewed in error. If you have 5 or 6 out of 5,000, and surely it's more than 5 or 6, I just am saying we have many, many, many permits that come through this department. So to the extent that some are missed or we issue something in error and then revoke it, that is how they are issued in error or renewed in error. To my knowledge, and I would certainly defer to Metro Legal on this, but to my knowledge, the CAPS case does not specifically hinge on how long the time period between when the permit was issued and when it comes to the government's attention that it was issued in error. At the end of the day, once the government is aware that they have permitted something that is illegal, they are authorized and indeed should cancel that permit so that we are not condoning illegal activity. With respect to the SP, okay. And by all means, if I say anything inaccurate, Metro Legal certainly correct me. With respect to the SP and the fact that this didn't exist at the time, the way SPs are designed to work and do in fact work, anything that is contemplated or specifically allowed is included in the SP. So if something doesn't exist at the time, the SP would, and then the people determine whether it's the council person or whether it's the property owners who want to allow this. Once this activity comes into being and people want it to be allowed, the option is to renew the SP to specifically allow it. And that is because, again, the SP specifically allows things. Anything that is not included is not allowed. So this was, I believe the ordinance with respect to this property was passed in August. The short-term ordinance was passed in October. I would, without being able to go back in time and relive it, I would suspect that short-term rentals were on people's radars and that, there was only a 3-month window. So I would suspect that short-term rentals were in fact on the radar. It could have been allowed to the extent they weren't on the radar. Once this ordinance was passed in October, which I think was our first short-term rental ordinance, if the people or the council person at the time wanted to allow short-term rentals, the proper avenue and method of doing that is to amend the SP. If it's not amended, it's not allowed.
Any other questions or more discussion?
I have to say, I didn't have a chance to read this beforehand, and I'm not understanding I understand that the permit was issued, it should have been issued, and there is some inequity in it, someone relying on something for a number of years, but then again, if you got something you shouldn't have had to begin with, and I think the other thing is we're here to determine whether the proper legal decision has been made, not whether to do equity. I do think there's some inequity about that, but I don't view that as what we're supposed to be doing. But I'll be very frank. I just don't have my mind enough to talk to understand the argument about what I think you're saying is the SP was not in effect at the time it was issued. Is that right?
No, the SP was in effect October of 2014. Okay. This permit was issued September of 15.
Okay.
And again, that would go back to what I was saying earlier, that to the extent we missed this at the time we issued it, once it came to our attention, and again, planning weighs in on these as well. Planning reviews the SPs, especially upon renewal, or honestly, even at the time of the application. Certainly now, planning reviews applications and renewals. When it's in an SP, because the SP, it's a zoning, rezoning that goes through the planning department and the planning commission. So the planning staff reviews the SPs and determines if the SP contemplated and allowed a short-term rental, and then advises codes and we act accordingly.
Okay, and I understand I got that wrong. I'm trying to understand there was another argument you were making that's other than that argument about it. I thought you were making an argument other than it's just not equitable because it's been issued and you shouldn't take it away. And that's what I'm not, and that's not your fault. You're being very clear about this. I'm having a hard time putting it together, and I'm new here too, so a lot of this I don't understand like a lot of the other board members, and I want to make sure you get heard on that. Because I hear you're saying something besides just, you shouldn't take it away.
Normally, this is the point of deliberation. We could always reopen this.
Okay, I'm sorry.
If you have a specific question
I'd
you
like
want
to-
to ask him, so please.
Can we reopen
Yes, of
for
course.
him to answer?
So you kind of have to take a little trip down memory lane on how many times this passed, and as everyone else is fully aware, this is a constantly moving target. So you have to keep up with what was in effect then. Then being BL 2014-909 and BL 2014-951. 909 was the companion bill to 951, wherein 909 says in Section 3, all residential uses are now allowed. So that second argument that I'm making is because of 909 and 951, because those are the two companion bills that apply to this property as it was permitted in September 30th of 2015, the state, and they were properly given a permit, in our opinion, because they were given that permit under 951 and under 909, now the state law, 601, now that covers them for this property. So to get to Ms. Chappell's point that she was getting to, I don't think this would apply necessarily today and to all SPs because they're going to have to fit into that small window of the ones that were under whatever law that applied or ordinance applied at the time. I think now, 100% going forward, it's a clear delineation that you're going to have it amended to the SP if that's where they're at. Now, obviously, there's going to be some creative arguments to that, but bottom line is everyone's on notice, or should be, for the purpose of these hearings, that if you're in an SP, you've got to get an amendment or you're not going to get a permit.
You read an SP.
In this case, yes.
Right.
Anything else to ask the applicant before we close the public hearing and continue deliberation? Okay. Let's close the public hearing, deliberation.
So, I reclaim my bona fides as not a lawyer. What is wrong with the argument that whenever you get your permit, whatever the law is then, this is kind of a broad question, but this is what the statute says. Right now, I'm getting my permit, so from now on, every year when I come back and renew that permit, why can I not enjoy the rights I had under that statute when I was first granted this? Now, that is a generally broad, I mean, I know there are a lot of things that can change, but
Okay,
in this case,
so Mr. Architect, when I built this building, things had to be built a certain way. Sometimes our laws grandfather, but other times you have to change it because that's what we do.
and that's an excellent point, because I think that would go to, for instance, to make the analog work, change of ownership, change of use is often when we say, great, you were fine up until now, but now you got to come into compliance. So, but I don't know that renewing a permit is a significant enough change to say you need to come into the new compliance. Again, uninformed legal argument, but that just from what I've seen, the way we talk about legally non-conforming, coming into conformity, that's the only way I can see it right now, and I'm open to be persuaded, but I tend to think that whatever requirements were when I got the permit, unless the ownership changes, the use changes, I feel like that they should be able to enjoy whatever rights they had under that legislation at the time.
I have a thought. I mean, when the permit was improperly issued, so he
Okay, well,
wasn't.
and there's that.
He wasn't entitled to the use he got. And that means anybody under that SP could come in and say, well, gosh, they didn't have short-term rentals, but it's okay, because actually they could come in and say, I've been doing it illegally for 2 years, and now I want a permit. So I think we have to look at what he enjoyed was illegal. He got the benefit
It
from.
was never legal?
It was never legal. He could not get a permit under the SP because it did not specifically say short-term rental was allowed, or at least that's how Metro.
Which gets back to the interpretation. So there's really two
That's how.
questions in this
That's
analysis.
how Metro enforces it anyway. I'm just trying to.
Okay.
You and I are.
There's something there that there doesn't seem, you keep getting renewed, and then told it was never legal. I get how someone feels that's
agree.
a tough situation. I also understand completely how that can happen, given the complexity of some of these SPs and, and the volume of permits. And so I don't fault Metro for
Right.
finding it when they found it. And the assumption is that if you have a permit, then is correct, and it probably is a whole lot harder to find that mistake on things that have already been issued, because you think that hoop's already been jumped through at some point prior. And they got benefit, 2 to 3 years of benefit from this, in which time they, most likely fully depreciated their movable assets and their furnishings and that kind of thing, and got a benefit from that too. So, and then again, I think that equity matters for another court, as Ross had mentioned. But to me, it's what I'm trying to figure out, and I'll defer to the lawyers on it, is that, did the language here, because it was written prior to the short-term rental rules, anticipate or include the short-term rentals, or is Metro right in saying no, if it doesn't specifically allow it, it has to be amended in order to do it? To me, it comes down to, that's the crux of it to me.
But the fact that if Metro is saying that it was never legal, or whomever is saying that, somebody did think it was legal at some point. It wasn't a mistake every time. To me, I'm saying it appears, as the appellant has claimed, that they have changed their view, the way they interpret it. See, I think that might be the biggest problem here, because it wasn't, I don't know, it feels more like a change in the interpretation at some point to me. And I'm really on unstable ground here in my thinking, so I'm trying not to confuse the issue. But in the analysis, I'm feeling more and more like the interpretation must have changed. Somebody convinced me.
I understood.
Somebody tell me I'm wrong.
Mm-hmm.
I understood. That's how I understood it. Or they just take it very plainly. If it doesn't say you can use it, it's prohibited. That's basically, if the use is not specifically listed.
Well, either way, I feel like we're giving, if this goes further, no matter how we decide this, I feel like we're giving them plenty of analysis, so I don't think our decision is going to be arbitrary.
No.
But there have been cases where, a Metro employee examiner, made determinations. They're dealing with some of that in the Nations and others, where they made an analysis that wasn't the proper one, and I think that, as it came up the chain, it was clear that no, you weren't supposed to have done that. You made a mistake.
This is a true item A.
So I think,
Did the zoning administrator err or not? And that's what we should be looking at.
Well, in that case, I said, and maybe that goes to David's point of where is there consistency?
Well, if I could add one thing to what Mr. Harper might be saying, if I'm understanding it right. So what I understand is the STRP ordinance didn't go into effect until October of 2014. The SP was passed in August of 2014. Is that right? So I don't know how you put STRP, maybe it was contemplated, because it was known that at some point the ordinance would go through council and be passed, but how do you put something that passed after the SP was written? How do you write STRP into the ordinance if it wasn't law yet? So I don't know if that...
Well, but that's a pretty close, if you, yeah, and again, I don't know the SP process to know how hard it is to include something in, if short-term's coming down the road, then you probably want to put it in there.
But how do you do it if it's not in the law? It wasn't
Yeah.
in the law at that time.
Or you say,
I don't see how
rental-
you do it. But I don't know if that's the
yeah.
argument.
Yeah.
I don't know if that's an argument, or I'm just trying to understand it. The non-lawyer in me is trying to understand it too.
Well, I'm starting to really feel like that, I'm starting to see the appellant's argument more clearly, or I think I am. And I'm leaning toward agreeing with the appellant, which in some ways maybe is punting the issue, because I think in these types of cases, generally, item A's are generally, a lot of them come to us to help guide, future decisions. But I don't even know, there was a mistake made, an error was made somewhere. Metro's claiming it was the previous issuances, and the appellant is saying the revocation. So I feel okay saying that there was an error.
So, I guess the SP said that you could use it for single, like 1 or 2 dwellings, isn't that, did I remember that correctly?
Either single or
And so, if you wanted to rent, if you own one of those dwellings, I guess, could you rent it by the month? Could a non-short-term rental, I mean, or would the SP imply that it's, and then if you could, how do you know? Is that?
I don't understand.
I mean, well, it sounds like that we're saying, it's always, and again, I've never thought of it, but it sounds like, people have always, if you had a home, you could rent it by the month.
Well, I think the difference is that a long-term lease is not necessarily, long-term lease is not in our zoning land use table. So a long-term lease is allowed as a residential use. A short-term lease is a specific land use that is specifically listed in the land use table and is therefore only allowed where it is specifically allowed.
But when did that become part of the land use table?
I believe in 2014, October 2014 So although.
But I guess that's what I'm saying,
it would have had to have been, because it came in the land use table after this SP was passed, they would have had to amend this SP to allow this use.
Why?
Because the SP zoning only allows what is specifically listed in that SP ordinance. It's on a case-by-case basis. So you could have an SP that says you can have single-family dwellings, 2-family dwellings, and restaurants.
So because.
But you can't have a short-term rental unless you want to come back and say single-family, 2-family restaurant, and short-term rental.
Because short-term rental is.
It's a separate use.
But now, if they got their permit after the short-term rental, after the short-term was part of the land use table?
Correct.
Okay. But I guess, and so if Metro Council were to codify a long-term rental as something over 30 days and put it in the land use table, then they would
be amending
every SP would have to be amended.
That's correct.
Okay.
If they wanted to allow long-term rentals, then they would have to amend the individual SPs to allow them in those individual districts.
Okay.
Any more discussion before we weigh a motion?
I understand the dilemma. I feel like I'd be acting too much like a board of equity to allow it. That's just where I am.
Well, I didn't understand. I mean, that was really helpful because, and we've been hearing these cases for 3 or 4 years, and this seems to be one we just haven't wrestled with. And every time you think you've heard it all, you get another one.
So does anyone have a motion?
I'll make a motion that the zoning administrator did not err, and the permits were properly canceled.
Okay, motion's been made. Is there a second?
Second.
Motion's been made and properly seconded. Discussion. Seeing none. All those in favor of the motion signify by saying aye and raise hands.
Aye.
Aye.
And opposed? Okay, 5-2. Very good. Ms. Lamb, can we take a break?
Next case for consideration by the board is case 2018-669. Barry King is the appellant and owner of the property located at 637 Gibson Drive. Is Mr. King here? Oh, there he is. Shown here on the aerial map. Mr. Osborne has a presentation of the case on behalf of staff. Seeing that there's no one here in opposition to this, after Mr. Osborne's presentation, Mr. King, you'll have 5 minutes to make your own.
So that you can aware of this, on October 5th, 2018, host compliance sent a notice. Looks like it operated from August 2018 to October 2018, about 16 rentals. The advertisement was removed around October 20th. To my knowledge, there were no complaints.
And no rentals or anything since.
I know the password. It just locked up at first. Okay. Are there any questions of Mr. Osborne? Okay. Applicant, please introduce yourself by name, address, and why you're here.
Hi, I'm Barry King, 637 Gibson Drive in Madison. Thanks for meeting with me on an additional day, and this has certainly been an education in civics for me that I've never had before. I listed my guest bedroom with Airbnb on August 15th, hastily and not understanding the complete process for doing so legally. I received some incorrect information from several people I trusted, and like others we've heard here, I assumed the many and difficult to navigate steps necessary for a permit applied to commercial enterprises or non-owner occupied homes. I apologize because as a business owner, I should have known better that when things are too easy, they usually are. In my defense, I was very motivated by an outstanding bill with Vanderbilt from my first hip replacement surgery earlier this year, $15,000. And I also would like to supplement my income to have my additional hip replaced. I had scheduled it for the end of this month. On October the 12th, I received the letter from Mr. Osborne, and I immediately contacted him through email to try to find out what I needed to do to come to compliance if that was possible. I was in the middle of hosting a stay for a business person. I immediately took steps to remove the listing and to cancel for future reservations. All this could have been avoided if Airbnb had simply asked for a permit number. And it's pretty stupid that it's not on there like that. I don't know what their motivation is. It seems
in the business of renting property.
Yeah, it's very misleading to everyone. I met with codes in person to find out what I needed to do. I went through all the processes of bringing my place into order to get a permit. Put my second surgery on hold until this is resolved. I'm asking for your forbearance, and in this case, if possible, to defer additional time penalty before I'm allowed to pursue obtaining a permit. I'd like to schedule my next surgery as soon as possible. I've lived with severe osteoarthritis for years. I live in pain every day. I would like to get back to having a pain-free and somewhat normal life, and this is the best way I can find to have enough money to do so.
Okay, so when was the last time you rented, and when did you get your letter from Mr. Osborne?
I received the letter on the 12th. It was the middle of the stay with a business person.
December 12th?
No, I received it on October the 12th, and the rental ran until the 22nd. So it was a 10-day rental to a business person.
Okay.
And they were already in your house?
Yeah.
How many people did you cancel? Future bookings.
Gosh, at least 2.5 months of people, not every day.
So would you say 10, 20, I mean, how many?
At least 20.
Okay. And you cancel them all, and so why didn't you know about our laws here?
I was misled, and it made sense to me that just renting a room would probably be no problem. And then when I did look at the site, all of those regulations seemed like they applied to a big business enterprise, not to just a homeowner trying to make a few extra bucks by renting out their guest bedroom.
Okay. Questions for the applicant? Do you have anything else to add?
No, sir.
Okay, thank you. We're going to close the public hearing. Discussion. Yeah.
I don't know how it'll go, but I'll move that the zoning administrator did not err. The applicant did rent without a permit. And based on the specific testimony in the case, applicant would be eligible to reapply for a permit on Monday.
What day?
Monday.
Motion has been made. Is there a second?
I will second it.
Motion's been made and properly seconded. Any discussion? Seeing none. All those in favor of the motion signify by saying aye. Aye. Opposed? Passes. Good luck. You are eligible to apply for a permit on Monday. You must obtain a permit before you relist on Airbnb or any other short-term site.
Yes, sir. Thank you.
Okay? Thank you.
Good luck.
Emily?
For the board to consider is case 2018-670. Stacy Kroger is the appellant and owner of the property located at 4965 Sulphur Creek Road, shown here on the aerial map. Mr. Osborne again has a presentation of this case for staff. Ms. Kroger, after Mr. Osborne's presentation, you'll have 5 minutes to make your own.
So we found out about this through host compliance, consumer notice on October 5th, 2018. There were about 6 rentals. We didn't have any other complaints, and there was advertisements removed around the 20th of October.
Okay. Any questions for Mr. Osborne? Okay, please state your name, your address, and why we're here.
Yes, so I'm Stacy Coker, and I live at 4965 Sulphur Creek Road. I was born and raised at this property, and my husband and I purchased the property from my mother in 2006. The property has a detached garage with a living space above it. That's the part that I'm looking at short-term renting. I believe we listed this space on Airbnb back in July, not knowing that I was needing the permit first. But when I went to codes down July 23rd to obtain the permit, that's when I found out that I needed the permit first. Also found out that I would need to move my property line. Finding that information out and already having 6 people scheduled to stay in August, I decided to go ahead and let them stay because I didn't want to inconvenience their vacations. I also immediately blocked all of the other dates so no one else could schedule and book with us, thinking that that was efficient enough. Early September, we had a survey come out and do his part, which cost me about $1,500. Also had to pay an attorney about $400 to have the boundary line agreement drawn up and filed. All of this was finalized on September 27th. I went back down to codes on October 11th, received a short-term rental case number. The same day, I sent an email to the fire marshal to get that last process going. The very next day, Friday the 12th, I received a letter from Mr. Osborne about being in violation. I emailed him immediately explaining the schedule was completely blocked and I had a case number, and I was waiting to hear from the fire marshal. Monday the 15th, the fire marshal contacted me. We set a date for Thursday the 18th. She came out, she did her part. She went to approve my listing on Friday the 19th. That's when she contacted me, letting me know that my account was blocked. I went back down to codes the following Monday, the 22nd, so I could file this case to appeal. I'm aware that I'm in violation, and it's supposed to have a up to 1 year wait. I apologize for my violation, and I ask that this permit be granted without any more wait time.
So
You had it listed, but everything was blocked. So, I mean,
Yes.
our notes say the advertisement was removed in October, but
And it is now.
it is removed,
At
but
the-
it was there, but it just didn't have, you couldn't rent anything because it was all blocked.
Correct.
And when was the last day you actually rented the property?
August.
August, okay.
So why'd you let these August people stay as opposed to canceling them?
Because I didn't want to inconvenience their these people take their time off,
What
find.
about the inconvenience of our metro laws to follow?
Right, and that's why I say I realize
Because
that
how
that's
many
a violation.
short-term permits are there, legal short-term permits in Nashville are there, Emily?
Close to 5,000, not quite 5,000, maybe 4,700,
5,000
something along
houses to
those.
stay in.
Yeah, that's a lot. I didn't
And-
realize there was that many.
Over 30,000 hotel rooms in Nashville.
Yeah.
So people could have found other places to stay. What is the property line? That didn't have anything to do with us, did it?
No, I was just stating the fact that just the process, the guy at Codes, and I don't recall his name, but he told me to do a timeline of all the stuff that I had to go through and all that, so.
Was there just a dispute of the land that you had? Is
Yeah,
that
so
what it
my
was?
property is attached to my family's farm property.
So that had to do with ownership, basically, what you
No,
own.
no, no, no. I just the property line cut through the building, the detached garage building,
Oh, gotcha.
and I
Okay.
just had to move it over.
Okay. Any other questions for the applicant? Okay. We'll close public hearing. Discussion.
Well, I mean, we don't like it when folks kind of know they're not supposed to rent and they do, and yet can certainly be empathetic to why people do that. And since it was the 6th and it was 4 months ago, I mean, I'm, and it's an owner-occupied home. I think that the last rental was far enough away that it is pretty close to what we would, we administer. I mean, I'm.
Any more
right at
discussion?
4
or
months.
should he make a motion?
Or,
I'm probably a little farther from you on that because of the 6 bookings. We've had a lot of people that have canceled. And so I think a 4-month penalty from the date of the application is where I would be.
Any more
The
discussion?
application was on October 11th.
yeah, I think that's probably too far for me.
Okay,
but-
well, why don't you make a motion
Make a
and see
motion.
how that goes?
Oh, good Lord.
It might be just fine.
Yeah, well, I'll move that the zoning administrator did not err. The applicant rented without a permit. Based on the specifics of the case, the applicant should, and the last rental being in August, the applicant should be allowed to apply for a permit on January 2nd.
Okay, motion's been made. Is there a second?
I'll second.
It's been made and properly seconded. Any discussion? Seeing none, all those in favor of the motion signify by saying aye. Hands up.
Aye.
Opposed? Passes 4-2. Okay. Emily, next case. Good luck.
Mr. Chairman, the next case is case 2018-671. I believe cases 671, 672, and 673 are all the same owner, different properties, but same facts and arguments. So if it pleases the board as well as counsel for Mr. Johnson, we would suggest that we hear the presentations for all 3 at the same time, but then have 3 different votes. And that's, of course, assuming council
I
is.
think that makes perfect sense. It may, just to give the timeline, may take a couple more than 5 minutes, but less than 15.
15, right?
If that's, but we won't need all 15 for at least our initial presentation.
And so before we'll make a brief presentation on this one. These 2018 671, 672, and 673. This is challenging the cancellation of a short-term rental permit based on these properties due to a change in ownership of the property. As I said early, often when properties are canceled due to a change in ownership, we receive arguments regarding whether or not a change in ownership does in fact cancel a permit. We rely on section 1716-215E1 and 1716-250U1, both of which state that no person or entity shall advertise or operate an STRP without the owner of the property first having obtained an STRP permit. So as I said earlier, our interpretation of this law and our consistent application has been that when a property is transferred, that by law, the new owner of the property is required to come in and obtain a permit before they can advertise or operate the short-term rental property. That's, again, what happened in this particular case. The property ownership was transferred at these 3 locations. The addresses are 116 9th Circle South, 118 9th Circle South, and 425 36th Avenue North. On all 3 of these properties, the owner transferred ownership to another entity. Codes then canceled the permits due to the short-term rental law that our interpretation has been requires such, and they are here today appealing that. Mr. McIntyre is here on behalf of the appellant and property owner. He'll present his arguments for the board. As we said, these 3 cases are being heard together, so he will have, Mr. McIntyre, you'll have 15 minutes to make your argument and presentation.
Thank you, ladies and gentlemen. Matthew McIntyre of Bell, McCann, and McIntyre, 2809 12th Avenue South, for appellant Harold Johnson. This is, and I will go back through the specific timeline because this case is actually fairly unique. I know you heard another case involving a transfer earlier with 2018-618, and we'll renew some of the same arguments.
I'm sure you're saying this case is unique because the other person lost.
This case is exceptionally unique, Mr. Ewing, and I'll go through the specific fact pattern here. Mr. Johnson, these are non-owner occupied permits, 3 for the 3 addresses, 116 9th Circle South, 118 9th Circle South, and 425A 36th Avenue North. He got these permits, and if you'll permit me, I've got this I thought a written chart might help a little bit. Mr. Johnson, can you kind of hold that up? And I'll go through the timeline with you. But Mr. Johnson first applied for non-owner occupied short-term rental permits on July 23rd of 2015 for the 2 9th Circle South addresses. Subsequently, on the 425A 36th Avenue North, he applied for that March 4 of 2016. Those permits were all subsequently granted. The ownership of the properties were by Harold Johnson individually in his individual name, the appellant here today. The permits were applied for and granted to Harold Johnson in his individual name. And again, we're going back to mid-2015 here. Permits were granted, and hopefully you can see the writing clearly enough, for the 9th Circle South on December 22, 2015 for both of those, and October 19 of 2016 for the 36th Avenue North. Then, and I know there was some comment about all the excellent advice a person might get having to do with short-term rentals or retitling property, I would assert with anybody that purports to give much advice on short-term rentals these days, especially over the last 3 years, put themselves in a lot of danger, specifically a banker who might have suggested in this case that it would be helpful to have these properties owned in a single-member LLC. That's what Mr. Johnson did. He retitled the properties in his own single-member, wholly owned LLC. And I will point out, just anticipating some of the discussion, this was a single-member LLC, completely owned and controlled by Mr. Johnson, 0 other owners. He was taxed as an individual through Schedule C. In some instances, it might be considered a disregarded entity, but without getting too deep into whether the LLC and Mr. Johnson were the same, regardless, the name on the title was changed to the single-member LLC on April 18 of 2016 for the 116 9th Circle, March 8, 2016 on the 118 9th Circle, and December 28 of 2016 on the 36th Avenue North. Then the permit was subsequently, all the permits were subsequently renewed, and you can see the renewal dates there. December 16, 2016 for 116 9th Circle South, December 9, 2016 for 118 9th Circle South, and September 29, 2017 for the 36th Avenue North. This is where Ladies and gentlemen, the facts of this case really converge from anything you've heard yet, and why we think this is the appropriate case to find that the administrator erred and that these permits should be allowed to continue. Shortly after that 2016 and 2017 permit renewal, on June 13 of 2017, Mr. Johnson, because he completely controlled the LLC, single member, wholly owned, transferred all of those, the name on the title, transferred them all back to his own individual name on June 13, 2017, so a year and a half ago. These were all back into Mr. Johnson's name. Not after any discussion with codes, but there were a lot of changes in the Metro Code through that time, and some concern that our LLC is going to be allowed to own or have short-term rentals in the future. I would point out, at the time the permit was renewed, every time, it has continued to be in Mr. Johnson's name individually. Permit has never been out of Mr. Johnson's name. He's never transferred the permit. He's never attempted to transfer the permit. Then, after the title reverted back to the name of Mr. Johnson as an individual, subsequent to that, he renewed the permit again, the Harold Johnson permit in Harold Johnson's name, on November 14, 2017, for 116 9th Circle South and 118 9th Circle South. The last, and then I've actually got those out of order, I think, on, I've got these two out of order, but he renewed the 425A on September 29 of 2017. So again, after, they were all renewed after it was back in Mr. Johnson's name with what's on the title in the Register of Deeds office. The 9th Circle South properties, the permit doesn't expire until December 22 of this year. On September 28 of 2018, Mr. Johnson received, or subsequent to that, Mr. Johnson received 3 letters dated September 28, 2018, from codes purporting to retroactively terminate these permits all the way back to, 2016 for a couple of these properties. The reason the 9th Circle South properties have not come up for renewal yet, because they don't come up for renewal until December 22nd. This one, and why you see an NA here, this one came up for renewal on October 19, 2018. Mr. Johnson was not able to file to renew that permit because the month before, codes had purported to terminate the permit. All through this process, Mr. Johnson has made every effort to follow this law in its many permutations and variations. He has always paid his occupancy and sales taxes since the very beginning. Of course, his property taxes and all other things that are required. And again, without, I'll just reference the arguments that you've heard previously in 2018-618, because many of those are similar, but the fact pattern here is what distinguishes it so clearly. The permit was never transferred or attempted to be transferred. The property did go, the name change went back and forth to a single member LLC, but then, again, at the time that codes and the administrator renewed Mr. Johnson's permit, this permit has been in Mr. Johnson's name the whole time, from day one to day now. Never left his name, never been in anybody else's name. A year and a half ago, when he renewed this permit on November 14, 2017, and even farther back for the 425A 36th Avenue North of September 29, 2017, the permit was in Mr. Johnson's name and the property was in Mr. Johnson's name. And so we would assert that this is the appropriate case. There is no provision in the code for termination in this situation. There was no transfer of the permit, and there was.
Now, are you LLC is different than a multi-member LLC in the way that I mean, there's certainly a difference in the way that the IRS views it, because you have a Schedule C instead, I mean, your individual accountant does all of your single-member stuff instead of, your business accountant that would give you a K-1. You don't get a K-1 with a multi-member LLC. So, I mean, are you saying that it's more like an individual than a trust?
It is different than a trust. In a lot of circumstances, a court will actually disregard, and I'm not saying whether those, I don't want to get too far down that rabbit hole in this case, but a court will disregard a single-member LLC sometimes, depending on how.
Board of Zoning Appeals.
Right, so that's why I'm not trying to go down too deeply there, but.
Is the issue a 12-month penalty or
There-
you no longer permit?
You no longer, yeah, because they want to have non-owner occupied.
There has been no penalty.
Yeah.
Okay.
But these would not be eligible for a non-owner occupied permit if we were just to say, hey, you go apply for a new permit under his name.
They're not eligible.
Not under the-
Yeah.
not under
I have a
the-
question. We have a letter from Ryan Snellen on case number 672. And according to Ryan Snedlin, I'll read this part of his email. The property was changed to his business entity, Progressive Development LLC, on March 8th, 2016, and on April 26, 2018, he subdivided the lots. Did he subdivide these lots?
I don't know the answer to that, Mr. Johnson.
Well, let's ask the applicant. Did you subdivide the lots?
We did an HPR, but no, we did not subdivide 116 and 118 North Circle South. No, sir, we did not.
So none of the properties in front of us were subdivided, or what did you do?
Not the individual properties that were applying for the BZA. It was not subdivided. It had been subdivided where we could do, we did a horizontal property regime on 116 North Circle South, thus making it 116 and 118 North Circle South,
And why did you do that?
so we could build two houses on one lot.
And that was before
That was
the,
way before, before any permit.
But it says that happened on April 26, 2018.
No.
So the lot was, is it one piece of property that's an HPR?
It's a horizontal, it's now two pieces of property,
And that's,
116 and 118 on Circle South.
I thought we'd only have one permit on an HPR.
that's a new provision.
Bill 608, that is the case. That was not the case in the original Council Bill 2014-951, which is the ordinance under which Mr. Johnson obtained the original permits, I believe.
So when did this happen again? What date did you do this HPR?
For 116, 118, that was prior to even the initial short-term rental permit application.
But what
This
date
back-
was it?
I think it was maybe 2014.
2014?
We haven't seen that letter, so I'm not.
I don't recall. It was way before we had any permits issued for a short-term rental.
Okay. What's there now? Are there two houses per lot?
There's only one house on 116 and one house on 118.
Okay. Other questions of the applicant?
So, well, actually, this is more a question for Metro, so I'll just.
Okay. Any other questions for the applicant? Anything else to add?
I would just point out, again, I understand, I've heard Metro's or Code's interpretation that you cannot apply for a permit after a name change, or you cannot operate, but we're not here for operating after a name change. What we're here for is termination all the way back in here in September 28th of, September 28th, 2018, all the way down here, trying to retroactively terminate even before Code's granted the permit to him.
How is it retroactively terminated if you basically change ownership, then according to Metro Legal, then your permit goes away?
Well,
That's no retroacting, that's just enforcing
Well, no-
our law.
Mr. Chairman, the letter, for example, the letter on 116 9th Circle South says the permit has been invalid since the April 18, 2016 ownership change. So they're saying it was invalid all the way back up here.
Yep, by law.
So that's retroactive from today. I mean, September 28th, we got a letter saying, we're saying it's terminated all the way back up here. And I would disagree that it's by law. I think that's code's current interpretation, but again, this permit, unlike the case you heard earlier today, they came in here, when they got their letter from codes, they had a whole different ownership. They were owned by a trust. Mr. Johnson, this property has been in his name since even before it was renewed. Certainly at the time we got the letter.
Progressive Development, that's not his name. Progressive Development LLC.
Progressive Development has not had its name on the title since June 13, 2017.
You said Mr. Johnson's had his name on this the whole time, and there's something progressive. That's not his
on the
name.
permit, Your Honor.
Oh, I know.
Okay.
But the property got transferred to the LLC, and I guess to me, I don't see a whole lot of difference between this one and the one we heard earlier, other than the nature of a single-member LLC versus a trust.
Well, the difference, Mr. Taylor, is the one you heard last time, when they got a letter from code saying you can't change the property, they were owned by a trust. They weren't owned by the permit holder. They were owned by a trust. In this case, prior to getting any letters, Mr. Johnson moved the property name back to Harold Johnson.
That basically he read in the news or heard that basically they were going to not allow short-term rentals to be held in LLCs, and so that's why you changed it.
But that's immaterial.
So your argument
No, it's
is
not immaterial, because you're saying that you should get good credit because you actually did it yourself, but the reason you did it yourself because you knew what was coming down the road.
And then the zoning administrator.
No, I mean, respond to that. Like I said, you stood up in front of us and said, oh, well, my client's not like the other case where when they got the letter, it was in some other's name. We didn't have that. And the only reason you didn't is because you read some article saying they're about to change this.
I'm not sure
The last case, you said they're different than us because when they got the letter from codes, it was in some other name. And you said that wasn't our case. But then you admitted your client, basically you or your client saw it in the newspaper that they weren't going to allow LLCs to hold these, and so you quickly changed it. And so you just can't say, oh, well, our hands are clean because our name was on there when we got the letter. You knew what was coming down the pike.
Well, and I think hands are clean or unclean. I don't think this is a hands unclean type of situation.
But you were trying to make the argument that that's why your case is different, that, you know, when you got the letter,
Here's what happened in our case that didn't happen in that other case. All the way back a year and a half ago, the property was named in Harold Johnson's name along with the permit. They're both in Harold Johnson's name, all the way back in June of 2017. Then, also different than that last case, codes renewed the permit after it's back in Mr. Johnson's name. The permit, when I said it's always been, I'm saying the permit has always been in Mr. Johnson's name. The permits have a name on it, an applicant name. In prior versions.
Same thing for the last case. They never changed their name on the permit.
The permit was always in the applicant's name.
You've had a change of ownership of the property.
But I don't think that's a problem. But what was different in that last case is when Code said, you don't have a permit anymore, it was being held by the trust. And then after that, they went and tried to retroactively put it back in to her name. That's not the situation
But
here.
the real violation was not when you got the letter. It's basically changing ownership.
Okay, there's not a violation here. There's no.
John Michael, violation of short-term rental.
Mr. McIntyre states correctly there's no violation, and I think that's an important point. I don't think that, let me clarify this important point lest the board be misled. He stated correctly there's no violation. I don't have any knowledge of any, and Mr. Osborne can clarify if I'm missing this, but any violation for, regarding the terms of operation.
Well, I'll say it differently.
Permit.
Cancellation.
The cancellation of the permit was effective as an operation of law on the date of the transfer of ownership, the date of the letter being much later, as was the case on the Belfort Avenue.
And I would say
case
it
you
is a
heard.
violation because it's a violation of the law that then triggers the permit to be canceled.
This is an important fact that distinguishes neither case but makes them much the same. We didn't go back and try to take to court either of these permit holders for the actions after the date of the ownership change and preceding the date of the cancellation letter. In other words, until we send you a notice letter, you don't know we've canceled your permit.
Okay.
So we're not holding, in this case, Mr. Johnson, in the prior case, Mr. Zhu, responsible for actions post-date of transfer of ownership. The operative question for us at the staff level, and I think here at the board level, is, was there a transfer of ownership? Does the law say that that then causes a cancellation of the existing permit and requires application for a new permit? We at the staff level have consistently said, yes, yes, there was a change. Yes, there is a law that says that requires a new permit.
May I ask a really simple question here? Does the law require that the permit, the name on the permit, match the ownership of the property?
So both in the original 628-030, which was the law that was applicable when these permits were originally obtained. See if I've got the language right in there. One second, Mr. Harper. You may remember that. The original iteration of the ordinance from 2015 doesn't say that the property owner has to be the holder or named entity on the permit, and I believe that we have a number from that era and even from more recent eras where a manager or representative for the property owner might be the named entity on the permit. So no, the original ordinance from 2015 does not say it must say Harold Johnson if Harold Johnson is the owner of the property.
And there's no distinction between an individual, single-member LLC and multi-member LLC in the ordinance?
The multi-member LLC, the publicly traded company, the individual, none of those, as long as it's not a natural person, it's in one big blanket category. That is pursuant to 608, the most recently passed law from the Metro Council on this topic.
Yes, go ahead.
Well, I was going to say, which was subsequent to the renewal here.
That's right.
And so when staff said that the appellant did not know that the permit had been terminated, well, neither did Codes didn't know the permit had been terminated. Nothing had happened to terminate the permit. What the contention from Codes is that the permit was terminated before they then gave him another permit here, or renewed it, something. But, if this had been terminated, he wouldn't have gotten the renewal. And then he probably could have reapplied at that time.
Yeah, the permit was canceled on October 1st, 2018.
Well, October, but the letters purport to cancel it back in 2016.
Well, it is not, when
They
you
do
got
not.
notice.
No, I'm going to respond to that. Factually, that's an inaccurate statement. The exact language of the letter reads, the permit has been invalid since, fill in the date for the three separate permits, March 8, 2016 on one, April 18, 2016 on the second, on one, December 28, 2016. Since they've been invalid since those dates. Not that they were canceled on those dates, not that we are prosecuting based on actions after those dates. Rest assured, this and any other permit holder, or in this case, prior permit holder, would know if we were prosecuting those cases because they would have spent the last several months in environmental court wrangling through that process. But we have not pursued that, as we do not in these instances, as far as actions preceding the date of the cancellation notice letter, which in this case, on all three cases, was September 28 of this year.
Okay.
And do you know if on June 13th, 2017, when the property was last transferred to Mr. Johnson, would those properties have been eligible for a non-owner occupied permit?
These are, I believe all three are R6 zoned. Council may know differently, but I think all three are R6 zoning. So based upon that, I believe in July of 2017, Mr. Taylor, Council Bill number 608 had been recognized by Metro Council through second reading, and the Planning Commission through or at least Planning Commission through second reading, was thus being treated as pending legislation.
In June.
Therefore, 608 was being applied at that time, and I do not believe if it were a brand new application, it would have been eligible for anything other than an owner-occupied permit in R6 zoning.
Okay.
Well,
In fact, I believe it was late April of 2017 when pending legislation status attached to that council bill.
Any more questions for the applicant? Anything else to add? Anything else to add?
no, thank you.
Okay, we're going to close the public hearing. Discussion.
I think there was a clear change of ownership. I just don't see the difference between LLC and a trust. I think they're separate entities. And it
So, am I misunderstanding that the law that we're, or the code that we're dealing with says that the permit can't be transferred? And it's the appellant's argument that the permit has never been transferred, nor is there allegation of that, only that the ownership of the property, and codes has said that the property ownership and the permit holder do not have to be the same person.
But I think their argument is that the law states that the owner has to apply for a permit, and when the ownership changes, the new owner did not apply for a permit. I mean, if you change ownership, to an LLC or to a trust or something else, I sold my house to you, even though I'm still living in the house and I have the permit.
You could sell me your house and I could leave you with a lease because I'm not ready to move in yet, or you're not ready to move out yet. You have a short-term rental permit. Are you allowed to keep renting because it's your permit?
No, but the ownership changed and I'd have to reapply. I believe, is that?
Yeah.
That's right. There is a provision of the short-term rental ordinance that says the permit cannot be transferred. There's also a provision that says you cannot advertise or operate an STRP without the owner obtaining a permit. So you have to read the two in conjunction.
But that would imply, and I guess this is your argument, that would imply that the ownership and the permit have to match.
No, I mean, the new owner could come in and obtain a permit, and the operator could, you could have a property manager who operates it.
But under the scenario, just because the property was sold out from under him.
That killed the permit because the...
Okay, so commercial property, we had some people in here applying that own a dozen or more STRP permits in a big building. Now, let's say that big building is owned by a corporation, and they all have these permits. The corporation sells the building. Everybody has to come and get a new permit on that day? I find that
Okay.
curious.
More discussion? Motion?
Am I wrong about that, real estate attorneys?
Our lawyer.
Well, they're not voting. I want to know what our lawyers think about that. Is that analysis correct? If a building is sold out from dozens of people with a permit in a multi-tenant building, everybody has to go get a new permit?
Our position, I mean, according to our reading of the law, it says if a property
I understand that, sure.
Yeah, I mean, if it was if they're separately owned units, yeah, right. You'd have to if it changed ownership, you'd have to get a new permit.
Okay. So this is an item A case, and we're trying to determine where the zoning administrator erred. So any motions to that effect?
I moved to uphold the zoning administrator's decision.
And, Your Honor, I'm sorry, Mr. Chairman, if we could just point out again, these are three different cases, so we would need to solicit votes. Three different
For
votes.
each individual one. Yep. So the first case we will do is motion on case number 671.
Moved to uphold the decision of the administrator.
Okay, is there a second? Motion's been made. Is there a second? I'll second it. Motion's been made and properly seconded. Any discussion? Seeing none. All those in favor signify by saying aye. Aye. Opposed? Did you vote?
I did.
Wait, aye?
Yes.
Okay. So it is 5-1. Passes. Next motion for 672.
I moved to uphold the zoning administrator's decision.
Okay, motion's been made. Is there a second? I'll second it. Motion's been made and properly seconded. All those in favor, any discussion? Seeing none. All those in favor signify by saying aye. Aye. Opposed? Okay, 5-1 again. Next motion.
Mr. Chairman, for this, since we've got three separate cases, we're asking for something slightly different on third one, although I think I see where this is going. We're asking because we were not allowed to make an effort to renew the third one because the notice of termination came.
Well, this is the deliberation part, so you've made your case and you've made your statement, so.
Just letting you know what I'm asking for this third.
Yes, that basically you
That
weren't
we'd be allowed to make an effort to renew even though the renewal date has now passed.
But when you
while we were
changed
in
ownership,
violation.
that's what kind of caused everything to, get difficult with Metro. So, is there a motion?
Move to uphold the zoning administrator.
Okay, motion's been made. Is there a second? I'll second it again. Motion's been made and properly seconded. Any discussion? Seeing none. All those in favor signify by saying aye.
Aye.
Aye. Opposed? 5-1. Emily, next case.
Yes, the last case, let me get to it. Last case for the board's consideration is case 2018-675 rather. Carl Kale, if I'm pronouncing that correctly, is the appellant and operator, owner of the property located at 300 Lady Bird Drive, shown here on the aerial map. Again, Mr. Osborne has a presentation of this case for staff. And after his presentation, the appellant will have 5 minutes to make your presentation.
So this one was originally permitted back in September 2015. It renewed in 2016 and 17, but the permit expired in 2018. There were about 5 rentals after expiration. It doesn't look like we've received any complaints on this. We sent a notice, there was an short-term rental permit on October 5th, 2018, and advertisement was renewed on October 23rd, 2018.
Okay. Any questions for Mr. Osborne? Nope. Please state your name, address, why you're here.
Sure. My name's Carl Colley, 4728 Holly Springs Road, 37221. It was an error on our side as far as not filing the renewal form. It slipped through the cracks. I didn't have a reminder, and
So you basically did not write out a check and send a Metro $50 while you're here.
unfortunately, yes, sir.
Okay. So,
But we got the letter, tried to come down and renew it, was told I would have to come to the appeal. At that time, we went ahead and took the listing down, and
did you cancel any listings?
we did,
How
yes,
many?
sir.
All of them?
6, yeah.
All
We
of them?
had December booked,
Okay.
and so we had to cancel December. And really just coming forward to ask if we could
Okay.
get it renewed.
Any questions for the applicant? Okay, we're going to close the public hearing. Discussion.
I think these are the cases that are fine to have the applicant reply on Monday, especially since the applicant has been last on our docket and has sat through 2 of these meetings, but I know that's not punishment. That's not punishment that we should really have to consider, but I think it counts. I'll move that the zoning, well, this is operating on an expired permit, that item 8, that the zoning administrator did not err. The applicant did operate on an expired permit based on the specifics of the case. The applicant may apply for a permit on Monday.
Okay. Motion's been made. Is there a second?
I'll second.
Motion's been made and properly seconded. Any discussion? Seeing none. All those in favor of the motion signify by saying aye. Aye. Opposed? Passes unanimously. Good luck.
Good luck.
Go get it. Okay. BZA is adjourned. See you soon. See you next week.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information about this and other programs, visit nashville.gov.